some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state government or autonomous bodies, etc. In such cases, although their appointments are cancelled, these candidates will have a right to apply to their previous departments or autonomous bodies to continue in service for those entities. This application must be processed.
Yes.
By the respective.
What have you done after that?
My lord, I had made an application subsequently, my lord. My lord comes to page 113, man.
113. 113 is an order of the court.
My lord. My lord, the petitioner is Vivash, my lord. That was the first round of litigation.
Yes.
My lord, based on that para 47, I had made an application before the commissioner. My lord, that application was not considered in terms of the judgment passed by the honorable.
Yes. The court bench directed them to consider.
Consider within a limited period, my lord.
Then what happened?
Nothing has been done by the respondents, my lord. Now, my lord,
yes.
This was a specific
would have filed a contempt application.
My lord, the Honorable Supreme Court, my lord, and contempt application was taken out by another candidate. Honorable Supreme Court has said,
not
lord,
before
my
Supreme Court.
grievance is not to punish the officer, my lord, but to get myself my right to life, my lord, the job to do, my lord.
This is an instruction from the Alipurduar engineer. They have forwarded everything to the commissioner. From the commissioner, we have sought for instructions, my lord. But that
was not given in the previous writ petition, my lord.
Not yet received, my lord. My humble submission, my lord,
17th March order was passed, my lord.
My humble
8 weeks was given, my lord. That has long expired.
Yes, how soon can you do that?
My lord, by next week, my lord. We have already called for instructions.
So by the next week, you will dispose of, you will pass an order. The learned advocate appearing for the petition, the grievance of the petitioner is that in spite of a specific direction passed by a coordinate bench by an order dated 17th of March 2026 in WPA 331 of 2026, directing the who is the third respondent in that?
Commissioner, that is the answer.
The Commissioner of School Education?
No, my lord. Commissioner, Panchayat and Rural Development Department.
Directing the Commissioner, MGNREGA, Panchayat and Rural Development Department, to dispose of the representation within a specified time, but the reasoned order has not been communicated to the petitioner till date. Full stop. The learned advocate appearing for the petitioner submits that for such reason the petitioner has been compelled to approach this court once again. Full stop. The learned advocate representing the third respondent submits that the reasoned order shall be communicated to the petitioner within a period of 2 weeks from date. Full stop. Such submission of the learned advocate for the third respondent is placed on record. Full stop. WPA number such and such stands disposed of by directing the Commissioner MGNREGA, Panchayat and Rural Development, Government of West Bengal, to pass a written and speaking order on the petitioner's representation dated 21/4/2025 and communicate the same to the petitioner as expeditiously as possible, but positively by the end, positively on or before August 14, 2026. So stop. It is, however, made clear that this court has not expressed any opinion on the merits of the claim of the petitioner, and all points are left open to be decided by the said authority in accordance with law. Yes, next.
Number 26.
Yes, Mr. Ghosh. You are for the petitioner?
For the petitioner.
Yes, what have you done?
Milord, I haven't done anything, Milord. I am only Milord,
Who is the answering respondent?
Milord SJDA and Milord the Shiliguri Mahakuma Parishad.
Who is,
Milord, this
you
is
are- you are for
the
SJDA?
My lord, I am representing respondent number 529.
529. Who are 529?
Milord the police authorities.
Yes.
Police authorities, the BDO Matigara and the BLLR.
Who appears for SJDA?
I along with Mr. Arjun Ram Mukherjee, we appear for SGDA, but copies.
You are appearing, yes. Yes, Mr.
No, no,
Bose.
copies have not been there. We have not received the
No,
copy.
Milord, my affidavit of service shows delivered.
What your officers are doing, they are not communicating with you.
No,
not
Milord,
giving
this is
copy.
the fifth round of litigation. And Milord would find from records.
Copy is not available in the Sarthak.
No, here we don't have. For circuit events, we don't have.
Circuit bench, Milord, we don't
We don't
have.
have.
You don't have.
It's a difficulty, Milord. Probably the state lawyers will be pursuing, but it's a difficulty.
Yes. Do you have an extra copy, Mr. Bose?
Milord, we have, Milord.
Give it to Mr.
One copy can be handed. Milord, kindly, pursuant to the first round of litigation, Milord, there was a inquiry conducted, the allegations.
What happened? What is the fact?
The allegations are illegal unauthorized constructions.
Against you or you have made a consent?
I have made the complaint, the
Who is for
complaint
the private
is
respondent?
against the private respondents.
The
The
private
private respondents,
respondent-
one of them is served.
11.
Service কার উপর আছে, দেখো, check করো। But 11 is Milord served, private respondent number 11, who is Milord the concerned person, and 12 Milord is the proprietorship form. So
Yes,
12
yes,
is
so he- yes, 11 is
inconsequential,
sufficient, yes.
11 is sufficient. Now,
Yes.
Milord, pursuant to the first round of litigation, Milord, an inquiry was directed to be conducted. The inquiry report is at page 27. Milord would find there are Milord serious violations with regard to ground coverage. Number one, 72.67% is Milord the deviation.
Page
On
27.
Page 27. With regard to Milord open space, Milord, there is a very serious violation, Milord. Rear, right and left. That is Milord at 5, 6 and 7 of the chart. And all those deviations, Milord, are underlined. Those are the deviations.
Yes.
Subsequent to the inquiry report, Milord, we preferred a writ petition once again, seeking Milord demolition of the entire structure. Because Milord, once the pillar comes up without complying with the open space requirement, that deviation probably subject to Milord correction, Milord, cannot be cured. Your lordship had passed an order on the earlier occasion that they are preferring a sanction prayer for revising the sanction plan. Let that revision or application be preferred. If it is permissible, let it be regularized. If cannot, steps in accordance with law. They preferred Milord an application for revising the sanction plan. That's they have submitted a modified plan. We don't know what has happened to that. The construction, Milord, continued in the meantime. Lastly, Milord, we preferred a writ petition once again, Milord, seeking Milord implementation of your lordship's order and Milord subsequently to take steps so that the deviations which cannot be regularized be immediately be demolished or Milord appropriate actions be taken. Milord takes the last order passed by this honorable court at page 42. 43 Milord is the page 43 Milord para 6 is Milord his lordship's direction in view of the above WPS
Remedial
also,
measures in terms of the report.
corrective and remedial measures in terms of the report. Thereafter, Milord, surprisingly, inspections after inspections are going on. Sometimes Mahakama Parishad is conducting a joint inspection, SJD is conducting an inspection, we don't know to protect whom. Till today, Milord, what happened pursuant to the last joint inspection that has taken place is unknown to us. Milord, kindly,
When the last inspection? took
Milord,
place?
kindly takes the last two communications at page 77 and 78. Page 77, Milord, is a communication from the Mahakama Parishad, which records it has come to the knowledge of the undersigned that in compliance to the order of Honorable High Court at Calcutta Circuit Bench Jalpaiguri dated so and so in WP number so and so, corrective and remedial measures have already been taken by the block development cum executive officer, Matigara Development Board and Panchayat Samiti. Accordingly, a date of joint inspection has been scheduled. Now, what corrective measures? The building is still standing, the deviation is still there, and according to their own report, Millard, these deviations cannot be rectified.
No, who is the authority who can take the decision? Whether it's the Siliguri Mahakuma Parishad?
It's Millard, the Mahakuma Parishad and the SJD, because the area falls under SJD also.
Yes, who is to take steps?
Millard, the district magistrate, who is the executive officer, Mahakuma Parishad.
Yes, yes, Mr. Dhar.
It's clearly report.
Yes,
পড়া গেছে একদম clearly order করা আছে।
Actually, sometimes you have to take instructions.
you are creating all problems.
I am not creating it.
Yes,
যাও। এই order করা আছে।
And Millard, I will just show Millard one order earlier passed by the executive officer at page 29,
30
page 30. 29 and
yes,
30.
why are you not taking steps? Why are you delaying? How many inspections you need after there's an inquiry report?
And Millard, the executive officer, Mahakuma Parishad, in his
If
order
your
has
authority
recorded.
cannot take, then some other ways are to be.
So for executing a demolition, lordship, the SJD is not the authority. It's
Who is the authority?
either the SDO or the GM.
Millard, the executive officer, Mahakuma Parishad, the district magistrate should take steps.
Yes.
Whatever has to be done, they have already done. And there is nothing on record to show that the structure which is standing today is compliant with the rules. In fact, Millard, can
Yes,
you take
who is
page
appearing
30?
for Siliguri Mahakuma Parishad?
Millard, they are served. Check.
Who appears for that?
Check. koro abar.
The state issue.
Siliguri Mahakuma, we are not appearing, my lord.
Yes,
The last option, someone from the state, right? So,
who appears?
now the last option, most probably someone from the state appear.
No, when the matter last came up,
Shogoto Banerjee.
who appeared?
Millard, one Mr. Shogoto Banerjee. Page
Now the
30.
panel has changed. Mahakuma Parishad?
27th April.
Yes, Mr. Rai Mukherjee, yes.
Yes, my lord. My lord, in this matter, my lord, earlier round of litigation, I represented the Siliguri Jalpaiguri Development Authority along with Mr. Deborshi Dhar. Now, this petition, my
Yes.
lord, we have not received, my lord. I do not know whether it has been
Mr.
served.
Rai Mukherjee, your authority has been served. If they do not give you copies, what can be done? Evidence of
Yes,
service has been filed. So
Yes,
Mr. Dhar has been given a copy. Please,
I shall follow this.
I'm passing it over for 5 minutes. I'm coming after 5 minutes. Please hold conference with Mr. Rai
And
Mukherjee.
soft copy though.
Please hold conference with Mr. Rai Mukherjee. I'm coming after 5 minutes.
Now, Millard, I'll just show,
Conference done.
Millard, I'll just show Millard one more page, Millard, for my satisfaction. At Millard, page 29. This is
29.
Millard, an order passed by the executive officer of Siliguri Mahakuma Parishad on 8th January 2025.
Page number?
Page 29, Millard. Yes.
Malad,
Millard,
we have
the-
copy of the
Millard,
writ petition just
kindly-
today only.
Millard, kindly takes the last portion once. The construction work, I'm placing page 30, Millard. The
Page 30.
Page 30. The construction work shall start only after modification of the building plan to the extent permissible. Any building construction in violation to sanction building plan or modified revised sanction building plan, if any, shall be demolished by the concerned respondent within 3 weeks thereafter. However, if the concerned respondent fails either to submit the modified plan within the stipulated time as mentioned here and above, or does not demolish the unauthorized portion, if any, after revision of the previously sanctioned plan by the Siliguri Jalpaiguri Development Authority, the Siliguri Jalpaiguri Development Authority will demolish the unauthorized portion within 2 weeks of such non-compliance. And this is Millard on 8th January 2025.
The 26.
So 1.5 years have passed. We don't know what sanction plan modification has been done. According to us, Millard, it cannot be modified. Once the structure has come up, the open areas cannot be changed. G plus 4. চলে আছে রে ওটা ওরা সার্ভিস করে দেবে অভিলাষ মিত্তল চিঠি
Yes, Mr. Rayam Mukherjee.
Malad, we have received the copy of the writ petition, Malad, today only. If your lordship give me a day's time, Malad, I can take instruction, but which, Malad, the SJDA has taken in the meantime, Malad.
But why have you issued this letter at page 78 saying that I have nothing to do? The report has been submitted to the executive officer Siliguri and district magistrate within a stipulated time frame. Mr. Ghosh, learned advocate, appealing
Milord,
for-
I undertake, Milord, to submit the affidavit of service in course of the day. Milord, it is ready but not affirmed. But I'll get it
on
affirmed
the
later.
prayer of Mr. Ghosh, learned advocate for the petitioner, leave is granted to the learned advocate on record of the petition to file the affidavit of service in course of this day. First up, Mr. Ghosh submits that in spite of repeated directions passed by this school, the unauthorized construction has not yet been demolished. First up, Mr. Ghosh draws the attention of the court to an order dated 8th of January 2025, passed by the executive officer, Shiliguri Mahokuma Parishad, directing the Shiliguri Jalpaiguri Development Authority to demolish the unauthorized portion within a specified time frame of non-compliance of the directions contained in the said order. Full stop. This court fails to understand as to what prompted the Chief Executive Officer, Shiliguri Jalpaiguri Development Authority, to issue a memo dated 2nd of June 2026, when there was a specific direction upon the Shiliguri Jalpaiguri Development Authority to demolish the unauthorized construction. First up, Mr. Rai Mukherjee, learned senior advocate, appealing for the SJDA 6 an accommodation to revert back with necessary instructions. First up, list this matter. 28th, this matter. 28th of July 2026, under the heading for orders. First up, the petitioner is directed to communicate the next date of hearing to the Shiliguri Mahokuma Parishad and file an affidavit of service on the next date. So it is however made clear that if on the next day the Shiliguri Mahokuma Parishad is not represented, the matter will be dealt with in the absence of the said Mahokuma Parishad. Yes, next.
Item number 29.
It is only.
Yes.
Your Lordship, 27 and 28 are SIR matters.
27, 28. Yes, SIR matters, orders have been passed.
Your Lordship, much
Similar orders have been passed.
Your Lordship.
Yes, Amrit Pandey নামটা রেকর্ড করে দেন 27.
Anamika Pandey.
Yes. Anamika Pandey, yes. The petitioner has paid for a direction upon the respondent authorities to disperse the amount claimed by the petitioner in the bill raised by the petitioner. First up, none appears for the petitioner at the time of call. No accommodation has been sought for either. Accordingly, CO number stands for default. Next.
Item number 30.
Milord, time for the petitioner. Milord, I believe there is no instruction with the state.
I'll tell you, there are a series of matters, around 14 writ petitions.
Yes, what is this matter?
Milord, illegal blocking of my vehicle in the portal of WBMTDCL by the fifth respondent without giving me any show cause notice, without order in writing, without any considering my show cause reply. Straight away,
Without
without order in writing and without any show cause notice. Straight away, they are blocking my vehicle. Milord, kindly takes up these rules.
It was, as per the letter, it was supposed to appear tomorrow.
Tomorrow,
And my lord, Ish, ভুল হবে, করেছো তো করেছো। And
the letter if you have mentioned
my lord,
tomorrow,
may I make one humble submission? My lord, there are 14 writ petitions.
15
before your lordship today. If those can be taken up Tuesday, or on next Tuesday, we are getting instructions all on similar facts, my lord, similar
Yes.
ones.
or one thing it can be done, since it has been blocked, there must be some reasons. You
Yes.
communicate the decision to them.
That can be done.
I think,
Milord, I am covered with the order of the coordinate bench. In the scenario where there was no so cause even given, straight away blocking, violation of principle of natural justice, how this can sustain even? Now they will come.
this is minor minerals,
Minor
transportation of minerals. Any penalty levied?
Yes,
Not at all communicated demand notice.
I'm
Milord,
asking
kindly takes
you,
up rules. first.
any penalty levied?
No, Milord, no demand notice has yet been supplied to me. Rules. Milord,
Yes.
kindly takes up rule
Demand
number
notice
25.
automatically
Yes.
generated
This
through
is
the
a matter
mobile.
where penalty has been levied.
Leave
Yes,
it.
my lord.
Each challenge has been
Milord, in
The
that
penal
case,
has been
the
generated.
order was passed. In my case, there was no order at all. My lord, kindly takes up the rules first. Rule number 25. I have handed over the rule. Rule number 25. 25(2). Every authorized officer seizing any property under these rules shall photograph the property and place on such property a mark in such a manner as may be specified, indicating that the same has been so seized, and shall raise a ticket on a centralized portal and inform the person from whom the property is seized in writing, milords, about such seizure and applicable amount for release of the property so seized. So as on that, there is no demand notice at all. When my property was seized, I was never at all intimated. Straight away blocking, milords. The moment I open the portal for generation of
Not
plurality,
so easy, sir. This is not so easy.
milord,
My lord, each alert automatically.
This is not so easy,
milord, this
sir.
can be, milord, this can be
my lord, it
disposed of.
says
I
the
have-
vehicle owner
One
may
more
be
judgment,
advised to
Lord.
contact.
You have
the
got my
officer.
judgment.
Judgment passed by Honorable Justice Om Narayan Rai.
Thereafter, I have passed. After Justice Rai has passed. You have got
Milord,
that
in the
judgment.
meantime, what my lordship has suggested, kindly takes up page number 7 onward.
Vehicle owner may be advised to contact the officer.
Page number 7, operative portion of the
Sir, I am
order.
aware of this. I have also considered this issue. I have also delivered a judgment.
Blocking of
I
the
am aware
e-channel.
of the judgment passed by Justice Rai. So, I have also delivered some judgments on this.
In the meantime, they shall provide me the reasons, and in the meantime, there may be an interim unblocking of my vehicle.
What remains to be decided in the writ petition? That's the final order.
That,
Can be passed at the interim stage, sir.
milord,
When it was blocked,
no date. No
So,
date has been communicated.
since when you could not generate your e-challan?
Milord,
What was the last date when your e-challan was
yes, milord.
generated?
Yes, milord.
Please tell me that.
Instruction is
On and from 19/6/2026.
More than 1 month, you could wait. You cannot wait for 2 more days.
Yes, milord, I can. Definitely. Justice Rai's order may be passed.
তারপরে তো মাইলর্ডের অর্ডার আছে
Oh,
সাই তো মাইলর্ড বলছে
There the penalty was imposed. So imposition of penalty, whether it can be done without giving an opportunity
free
of
of
hearing.
hearing.
So it's not merely blocking. Blocking coupled with penalty.
Penalty. Milord, as on date, it has not been intimated. What is the penalty levied?
You are lucky that till that penalty has not been levied. against you.
But I cannot,
That
I
is-
cannot ply my vehicle. There is non-generation of the royalty in the portal.
You know the reasons for not for blocking. You know the reasons. You know, the petitioner has alleged that the generation of e-challans have been blocked by the authorities without assigning any reasons therefore. This is the paragraph. Mr. Bhattacharya landed additional government period seeks an accommodation to revert back with necessary instructions. When tomorrow?
Next week. And there are 14 cases, my lord, listed today. 15 cases.
Same. I'm
Not-
telling you, the reasons will be the same
Kindly takes it up day after tomorrow.
day after tomorrow.
Milords, my affidavit of service may be taken.
Dividend service taken on record. Kuruddin, list this one. Monday,
Monday.
list this matter on 27th of July, 2026 under the same heading.
My lords, may we hand over the
What?
case numbers?
Well, item number 30 to 45 except 35.
Except 30.
Except
35.
35 is a different matter.
Different, it's a different.
So 35 chara same order.
Milord, in all 15 matters, I will submitted my affidavit. Item number.
Yes.
Grateful, my lord.
Milord.
Get-
Milords, Milords,
Our serial number.
Milords, I apologize, one indulgence, Milords. Milords,
Yes.
I was on my legs before court number 9. By the time I reached before Milords, Milords had dismissed 29 Milords.
29.
Milords, it's appearing for the first time, Milords. I apologize, Milords. I was
All
on
right. All 29.
grateful.
Yes.
Grateful.
29, yes.
Milords, affidavit of service.
Yes.
Milords, I appear for the petitioner in this matter, Milords. Milords, what has happened? Milords, the respondent number 2, the chairman of the Malbazar municipality, had issued an order, Milords, for supply of solar powered panels for installation in the entire city of Malbazar. Milords, I complied, means as per the direction of the municipality, I supplied the said solar systems, Milords, have been installed, running properly. No complaints received by my client till date, Milords. Milords, I have made multiple visits to the office. Milords, it is not in doubt or Milords, it has not been contested by them on any occasion that I am not receivable to the said claim amount, Milords. Milords, I have annexed all the bills they're receiving, Milords.
When have you raised the bill?
Milords, the bills were raised. Milords, the bills were raised in the month of September 2023, Milords. I've annexed the e-way bills, Milords. The e-way bill is at page number 24, Milords. The goods were supplied. Milords, the receivings are, Milords, on page number 30 onwards, 33 onwards, Milords. Page 33, Milords. Page 34, received by the electric department, Milords. Again, the EV bill has also been received by them, Milords. Thus, thereafter, I
You have
made.
made a representation.
Yes, Milords. On
I can direct them to take a decision on this.
grateful, Milords.
Ashwin, the petitioner states that pursuant to work order issued by the Mal municipality, by the authorities of Mal municipality, the petitioner has supplied the you have installed also,
No, Milords.
or you have only supplied?
I've only supplied,
Have
Milords.
supplied the required units of solar light system.
Yes, Milords.
Solar light system. First of the petitioner claims that the petitioner has raised bills for such supply of materials, but till date, the bills raised by the petitioner has not been cleared by the authorities of Mal municipality. First of paragraph, petitioner submitted a representation dated 24th of September
Milords,
20
2nd of February 2026. 2nd of February 2026.
2nd of February,
Yes, my lord. My lord, page number 39. my lord.
submitted a representation before the chairman Mal municipality by a letter dated 2nd of February 2026, requesting the said authority to release the payment to release the payment in favor of the petitioner. Footstep. The learned advocate appearing for the petitioner submits that in spite of receipt of such representation, no decision on such representation has been communicated to the petitioner till date. Footstep paragraph. Without entering into the merits of the claim made by the petitioner in the letter dated 2nd of February 2026, comma, WPA number such and such stands disposed of by directing the chairman Mal municipality to consider the representation of the petitioner dated 2nd of February 2026 and to consider and dispose of the same by passing a recent order and communicate the same to the petitioner immediately thereafter. So the recent order shall be communicated. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 6 weeks from the receipt of a server copy of this order, together with a copy of the representation dated 2nd of February 2026. Footstep. If the said authority decides in favor of the petitioner, comma, all consequential steps thereafter shall be taken by the said authority. Footstep. The respondents have been served.
Yes, my lord.
একদম উপরে লিখে দেবেন এভিডেন্স সার্ভিস ইউ আর ফাইল
Yes, my lord.
evidence service একদম উপরে লিখে দেবেন evidence service filed in court today is taken on record. The learned advocate appearing for the petitioner submit that the respondents have been duly served. Full stop. In spite of service, none appears for the respondent.
I'm grateful to you.
Yes, next.
Order number 35.
Lordship, Mr.
Item 35, I am for the petitioner. My learned advocate
Yes.
record is there, my lord. The petition, the
Yes.
service is not complete because the matter is due to appear on 24th of July.
24th.
24th of July. Service is not complete, my lord, so my agreement service is not ready.
Five to go there.
Six nine.
No, the matter is due to appear today itself in the presentation form.
Lordship, it is 24th, Lordship. Even in the online, it has been written 24th.
Please see in your presentation form you have filled up.
Lordship, this is not my case, Lordship. This is some other case has been tagged with this.
What is your number?
1269, Lordship.
What is the name of your client?
Dr. Rajeshri Chamaria.
मेरे तो मनोज कुमार शॉट Please give your what is the slip you are showing?
Lordship.
1269. Come on. কিন্তু ফাইলিং সেকশন থেকে দেখিনি, এটা তো নাম্বারটা কারেকশন করতে হবে। It has been submitted to record করবে তো, ফাইলও তো নেই। Alright, দেখে নেবেন না। Alright, ওটাকে দেখে পাঠান। এটা নোট করে রাখুন একটু 20. Yes, yes, call the next matter.
Item number 46.
Yes, 46 who is appearing.
Lordship of 46 and 47. I'm for the petitioner, Lordship, the
46 you are appearing.
46, yes, Lordship.
Yes.
Lordship, in this matter, I'm paying for next circuit because the advocate on record misplaced the brief. It's an old brief 2024. So, Lordship, on that ground, Lordship, I'm paying to next circuit, Lordship. It's a matter of interest or gratuity.
The learned advocate appearing for the petitioner submits that the brief has been misplaced by the learned advocate. To stop, he prays that this matter be placed before the next available circuit bench. To stop, on the prayer of the learned advocate for the petitioner, list this matter before the next available circuit bench. Yes, next.
Item number 47.
47, same, Lordship.
47, same order. Next.
48.
Yes, 48. Slowly, slowly. Yes,
48, my lord, I am for the petitioner.
yes,
I'm praying for interest of gratuity and arrear pension.
yes.
The affidavit of service and a lordship order corrected.
Yes. Yes. Disposed of. Evidence service taken on record. State is represented by learned advocate. Yes, next.
49.
49, my lord, I'm for the petitioner. My lord,
Yes.
this is for gratuity and arrear, Lordship. Service has been completed, Lordship.
Yes.
Lordship, the petitioner was superannuated on 31st of August
Yes.
2024.
Yes.
Yes, after his retirement, Lordship, the PPO was issued
You have
on
the
5th
copy of the order.
Oh, Lordship, I
Don't have the copy of the order.
corrected.
Yes.
Lordship, the payment was issued on, payment order was issued on 5th of 5/5/2025. That is
Pension
May.
payment order issued on
5th of May.
5th May, my lord.
5th May 2025.
PPO 5th of May
2025.
2025. Yes.
And the amount was disbursed on the 13th of July 2025. Lordship, now I am praying for the gratuity.
13th of July 2025.
Five.
Amount disbursed.
Yes, first amount was disbursed.
Yes.
Yes, Lordship, I am praying for the gratuity and arrears, Lordship.
Interest on
Interest on
gratuity.
gratuity and arrear.
Yes.
Yes, Lordship.
For the period from.
Period from the best, Lordship.
Yes. Yes. আগেরটাও তো আছে, এই দুটো ফিগার গুলো দেখে নিন, করে দেবেন। ঠিক আছে, EPO 5/5/2025 amount disbursed 13/7. Interest on that. Yes, disposed of next.
Big Lordship.
বলো তো,
50 similar, Lordship. It's also gratuity and arrear service has been completed.
What are the dates? Please give the dates.
Dates, yes. Lordship, the petitioner was superannuated on 28th of February 2025. He retired.
Retired on
28th of February 2025.
28th February 2025.
Right. Then the order was issued on 17th of June 2025.
PPO 17th of June 2025.
25, Lordship.
Amount
The
received
amount received on 22nd of July 2025.
22nd of July
Yes, Lordship.
2025.
Fine, Lordship.
So interest on gratuity.
Yes, Lordship. Paying for interest on gratuity.
Yes, disposed of. Next.
Thank you, Lordship. 51 also, Lordship.
Yes.
Item number 51, this is pertaining to overdrawal amount, your lordship. We have seek for instruction, your lordship. It is yet to come. So kindly.
Overdrawal.
It's an overdrawal, Lordship.
Yes, your lordship.
Then
So kindly fix this matter next week. your lordship.
overdrawal after the retirement.
Retirement.
Yes,
After
your
the
lord-
retirement.
Can you recover the overdrawal amount after the retirement?
That has already been returned by the petitioner, your lordship. We have seek for instruction from the
All right.
next week, your
There's
lordship.
settled, no, Lordship.
Next week,
Next week, your lordship.
on the prayer of the learned advocate for the state list is better in the next week.
Grateful, your lordship.
Yes, next.
Item number 52.
52, Lordship. This is gratuity, interest on gratuity and area, Lordship. Petitioner husband was
Interest
the,
on area
Gratuity.
gratuity. Yes.
yes,
Retired on
retired, Lordship. Petitioner husband was he died on 15th of 10, 2029. During
died
the
on
service,
15th of
10th, 2029.
2009.
2019, the Lordship. I beg your pardon, Lordship, 2019.
2019.
19,
Yes.
Lordship. Then
Then-
the PPO was issued on 5th of April 2023.
So this is issued in the name of the wife.
Issued in the wife, Lordship.
Wife. Yes.
Then the payment was disbursed on 3rd of June 2023.
Disbursed on.
3rd June 2023.
Yes.
Yes. Now I'm paying for interest on gratuity and area, Lordship.
Yes.
Two next.
Yes.
Lordship.
This one.
Just come.
Huh? আছে আর format আছে yes দেখতে হবে
53, Lordship. This is again, Lordship, on interest on gratuity and area, Lordship. Petitioner was superannuated, retired from his service on 31st March 2018.
retired on
31st March of 2018.
yes
And then the payment was disbursed on 20th.
PPO issued on
Your Lordship. Lordship, PPO was issued on 30th April 2019.
13th April 19 amount
Then the first amount was disbursed on 20th December 2019.
20th December
December.
2019
Yes, Lordship.
interest on gratuity
Interest on gratuity and area, Lordship.
yes
Great.
yes next
Item number 54.
53.
yes yes
Milord, the mother of the petitioner was assistant teacher, Milord. Thereafter retired on in the year 2004, Milord, upon attaining superannuation. Milord, thereafter switch over the from CPF to GPF. Milord, thereafter, Milord, the option
this is not gratuity
No, your lordship, this is not gratuity. This
Milord,
is
why
from
you
the pro
mentioned on
rata.
the gratuity
Yes, your lordship,
Milord,
this
this
is
is a
not.
new motion, Milord.
oh this is a new motion
Yes.
Your lordship, this matter also we have seek for instruction, but we are yet to receive it, your
instruction
lordship. Yes, your lordship.
Milord,
Because this
switch
is
over from the option of GPF to CPF to GPF, Milord. Thereafter, Milord, I have refunded the employer's share, Milord, at annexure page number 18, Milord. This is the TR Form 7 challan. Milord, only difference is that, Milord, the mother of the petitioner was as assistant teacher. Milord, subsequently mother expired. Thereafter, the father expired. Now she was survived by two sons, and the elder son has given no objection to the younger son that if he receives the area pension, he does not have any
area
objection.
pension
Yes.
For what period?
Area
What is the amount?
Keep your amount. of-
Area
Because they
pension-
will not be entitled to family pension. They will not be entitled to family pension.
Lordship.
Milord, on this code, I have a order passed by coordinate bench. Milord,
Sons will be entitled to family
Yes.
pension.
Justice
Your
Sinha.
That is what we
Backdated
have.
pension में 2004 to 2000.
That's the areas,
Areas,
pension,
Milord.
not the current pension.
Another issue, Milord, that there are two legal heirs of the mother, two legal heirs, Milord. One have made petition before the law,
I have annexed the no objection certificate also.
no objection certificate will not do, Milord. The both petitions should be there. According to my understanding.
Kindly takes up page 26, Milord. Paragraph
This will
5.
be the facts. When the, who was the teacher?
Mother of the petitioner was assistant teacher, Milord.
Mother of the petitioner was the assistant teacher.
Assistant teacher.
When did she retire?
Milord, she retired in the year 1st June 2004 upon attaining superannuation.
Mother retired on
1st June 2004. Upon,
1st of June 2004.
Milord.
Yes,
Subsequently, Milord,
under CPF.
under CPF, Milord, old PPO was issued. Milord, thereafter, Milord,
Yes. Then
Milord, she,
who exercised the option?
Milord, mother of the petitioner exercised the option at page 17, annex 32.
Page 17.
Yes, this is the format of option. Milord, thereafter, Milord, refunded
What is the
em-
date? 30th of July 2014.
Yes, yes, 30th of July, Milord. Thereafter, on the next page, Milord, my lord will find
Right.
that refunded the employer's share,
30th
PR
of
Form 7 Chalan.
July 2014. Then amount refunded when?
Yes, on Milord, 2nd September 2014.
2nd September 2014.
Yes, by way of PR Form 7 Chalan.
Yes.
Milord, thereafter, fresh PPO is issued, Milord. Milord, my lord will find column 6, Milord, left hand side, the pension with effect from 2nd September 2014.
Yes, 2nd September.
2014. Pension was
Yes.
issued with effect from 2014, Milord.
Yes.
Thereafter, Milord, paying for arrears from the date of retirement to the date of refunded.
Pension from 2nd September.
Date of retirement to date of refunded. Milord, and Milord, no objection was given by at page 26, paragraph 5. Milord, I have also annexed the legal heir certificate.
Yes, what do you say?
We have to first, Milord, we have to take instruction. We have for instruction yet not come, Milord. And another thing, Milord, there are the legal heir, two persons are the legal heir.
Yes,
One has given no objection to the other.
At least, Milord, the both persons should be as a petitioner, Milord. Should be petitioner, Milord, as a.
Milord, legal heir certificate, my lord will find page 22.
But legal heirs, he has given no objection.
Yes.
What is the difficulty?
Paragraph 5. Milord.
Well, kindly
Page
make
20.
it, Milord, Monday, Milord, we have to take instruction.
Monday.
Milord, settle position.
What settled position?
No, we have to take instruction.
He is not entitled to take instructions.
Milord,
Then
my copy of the order.
copy of the order. What copy of the order?
Passed by coordinate.
Yes.
The son is entitled to get the arrears pension.
Arrears will be entitled to. There is no difficulty on that.
Copy of the order.
The arrear amount you will be entitled to.
Basically, 14th to the issuance of the revised PPO should have great.
Mother passed away when?
2021, Your Lordship. Page 20.
Your mother passed away 2001. Minority side from page 20, death certificate is annexed. 21. Date of death 23 August 2021. Sequentially, not father also passed away. On the next page, page 21, date of death 18 June 2022.
Ashwin. The learned advocate appearing for the state seeks time to take instructions. Full stop. Monday.
Typographical error in the
All matters typographical error. All right. Typographical error where?
Milord, in the prayer portion, Milord.
Typographical error. Leave to correct. Yes, next.
I'm grateful.
In the prayer portion. Yes, next.
Item number 55.
Yes. Yes.
For the petitioner, Milord.
Yes. This is also CPF to GPF.
She was working as a assistant teacher in municipality primary school. Thereafter, retired without availing the terminal benefits. Trained for terminal benefits. Retirement, provident fund gratuity, and other terminal benefits. I have made a representation before the respondent authorities at page 25.
This is municipality.
Yes. Assistant teacher.
Who is appearing? You are for the municipality.
No, my lord, state.
Which municipality?
Jalpaiguri.
Jalpaiguri municipality. Jalpaiguri municipality. I have served.
The petitioner was serving as an assistant teacher of a municipal primary school.
Municipal primary school.
Yes, of a municipal primary school. Who was serving as an assistant teacher of a primary school run by the municipality. Retired from service on superannuation on 31st of July 2023. First up, the petitioner states that after his retirement from service, the pension payment order has been issued and he is receiving the amount on account of pension on regular basis. The grievance of the petitioner is that the municipal authority has not released the gratuity and the provident fund benefits in favor of the petitioner. Petitioner submitted a representation before the chairman, Jalpaiguri municipality, by a letter dated 10th of December 2025. Mr. Das, learned advocate, appearing for the petitioner, submits that in spite of receipt of such representation, no decision on such representation has been communicated to the petitioner till date. First of paragraph, without entering into the merits of the claim made by the petitioner in the representation dated 10th of December 2025, WPA number such and such stands disposed of by directing the chairman, Jalpaiguri municipality, being the third respondent, to consider the representation of the petitioner dated 10th of December 2025 and dispose of the same by passing a reasoned order after affording an opportunity of hearing to the petitioner and communicate the reasoned order to the petitioner immediately thereafter. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 4 weeks from the receipt of a server copy of this order together with a copy of the representation dated 10/12/2025. Yes, evidence service you have filed. Evidence service filed in court today is taken on record. Mr. Das submits that the municipality has been duly served. First up, in spite of service, none appears for the municipality. Why? Why? You are seeking direction upon the municipality. You have not served upon the municipality.
I shall communicate this order within the course of this day. I shall communicate the copy of the order.
Mr. Das, learned advocate, appealing for the petitioner, submits that the municipality has not been served. First up, petitioner is directed to serve a copy of this petition upon the municipality and file an affidavit of service on the next date. This matter on 29th of July 2026. Yes.
Grateful.
Yes.
Item number 1.
Yes, please appeal.
This is a provident fund matter. Lord, I went up in appeal from an order levying damages and charging interest. No, not
Yes.
charging interest.
You are
I went up in appeal.
I'm appearing. Lordship is a appeal has been preferred against the order of the tribunal. That has been they availed the last page number 128.
There was. May I just indicate?
Appeal that
There is an order.
20% of the
There is an order levying
would be
damages and
deposited.
charging interest. Now, not interest amount
That
I
is
have
page
deposited.
number 128. Page number 128. And in this order, a tribunal has been is to direct them to 20% be deposited in favor of the respondent authority within 1 month, Lordship. That 1 month has actually expired. Why it is passed on 13th May 2026. Then that compliance has not been complied with. Even on 18 May 2026, the compliance they have not been held compliant. Even you, my lord, come to page number 28 in their 8 of their petition, para number 15. The next date is fixed on 31st July 2026.
Paragraph number
15. Paragraph number 15.
On 31st of July.
July.
Yes, let me hear Mr. Majumdar now. Yes, Mr. Majumdar.
There was an order levying damages and charging interest. Interest order we
Yes.
have not challenged. We are liable to pay. We had paid. Number in so far as damages is concerned, I have a right to prefer a statutory appeal. There is a judgment.
Where is that order, Mr. Majumdar? Where is that order?
Page 94. Page 94. Pages 96 to 100 is the pages 96 to 100 is the order. Not ordering is the essential portion of that order. I have only challenged the damages
Yes.
portion of it. Now, I'm not.
Please show me the operating part.
Please come to page 118. 118.
118.
Mine. That's the calculation, and page 100 is the operative portion which your lordship might be searching for. 100.
Yes.
100. Thus, having applied my mind to the facts and circumstances of the case stated above, and having perused the records and taking into consideration the defaults committed by the employer and the length of default, number of defaults, the period of delay, the frequency of the default, and the amount involved, and the loss of interest suffered by the Employees Provident Fund organization by not being able to invest the amount in time due to delay in remittances, and the consequent loss of interest to the beneficiaries. This is the most important part of it. The increased cost of administration and the deterrent element inherent in damages, I proceed to assess the dues as per the following rates. So that the various rates are mentioned, and at page 101, the amount is mentioned as 1,41,67,408.
Yes.
Now, I have preferred a statutory appeal. On the face of it, I can show that loss of interest to the members cannot accrue to the damages, because there is a separate provision for levying, charging penal interest. For that, I have paid that amount. So this is on the face of it, this is a perverse, not application of mind. Be that as it may, when I preferred the statutory appeal, there is a judgment of the Honorable Supreme Court pronounced in 2016. Miss Kundu is probably there, who can hand up that judgment to your lordship. Reported at 2016 LLR, page 55. The SCC online print is of 2010. Come to paragraph 4 of the judgment.
Yes.
Having heard the learned counsel for the respective parties, we are unable to accept the submissions on behalf of the respondent. Respondent was the Provident Fund. Having regard to the fact that had it been the intention of the legislature to also include the principles incorporated in section 7.0, 7.0 requires a certain percentage of the determined amount to be deposited. Of the same would have been indicated in the provision relating to filing of appeals against such orders. Section 7.0 makes specific reference to orders passed in terms of section 7A, where it has been laid down that no appeal by the employer shall be entertained unless he has deposited 75% of the amount due from him as determined by an officer referred to in section 7A. The proviso to section 7.0, however, grants the tribunal discretion for reasons to be recorded in writing to waive or reduce the amount to be deposited under the said section. There is no such provision as far as section 14B is concerned. So the court held that in preferring a statutory appeal from an order under section 14B, the prerequisite of deposit is not mandatory.
Yes.
If this is an order under section 7A, then the tribunal can, the appellate tribunal can invoke its jurisdiction and insist upon reduction or modify the amount of deposit required to be made, which is otherwise 75% for a 7A order. Now, this is an order under section 14B. The Honorable Supreme Court in this 2010 judgment laid down that I don't have to deposit an amount in appeal.
Yes.
Now, on merit, I can immediately satisfy your lordship, but this is not from the original order. This is only from an interim order in appeal. Now, I was only beseeching your lordship that since the order on the face of it says that it has applied wrong test leading to perverse result, that's the original order, and the appellate tribunal has not taken into consideration this factor that I am not required to deposit this amount. But the imposition of 20% deposit as a matter of course, not for the purpose of not adjudication of the appeal, is probably going beyond the dictum of this judgment.
Yes, what do you say?
Subnet, I was only praying that this matter be remanded to the appellate tribunal. It can hear it afresh.
Lordship, my respectful submission is that there is a conditional state. Lordship,
Relying upon this judgment which says that this should not be done.
that is been Lordship kindly they can agitate it before this the tribunal actually because of they did not prefer that moment because of this order actually now not in force. The 1 month that has been there has been a,
He's challenging.
he is challenging after 1 month, Lordship.
Maybe.
My Lordship, after 1 month.
If he is challenged, he says, I am not liable to pay this. If you want to consider this judgment, you can come back.
Lordship, can you give me the, one day may given. I have
Mr. Mojumdar, you also ought to have
Sure,
placed
sure.
this judgment before the authority.
Before the.
But I can't say whether this has been flagged or not. Obviously, the judgment does not, the order does not record the
It has
judgment
not
having
been
been
flagged
placed.
because
Yes, yes.
it has been flagged after it has come to you. After it has come to you, you have taken this point.
No, it was my
So-
part of my duty.
Yes, so it was neither flagged before the authorities.
No, it does. It
Yes,
doesn't
Lordship,
appear.
I have no judgment right now in me. With me, kindly give me 1 day, Lordship. I can consult this judgment. I have no idea.
Or
about-
one thing I can do, I can set aside, direct the authority to consider
Consider
this
it
judgment
afresh.
and to take,
Yes.
to consider it afresh after considering
lord.
this judgment.
My lord.
Order dated
Or to
13th.
revisit this order, in the light of this judgment.
My lord.
Or you want to come back? What do you want?
Lordship, this is best for the go for a revisit the matter to on the light of this judgment. That is been.
Yes, Mr. Mojumdar, I am saying
lord,
that
We
I
go
am
back
giving
before
you
the
liberty
tribunal.
to approach.
Yes.
Yes, before the tribunal.
Tribunal, yes, Lordship.
No, it gives us a limited protection till such time it is considered.
Lordship, that is been 13th.
What is the next date? 31st of July?
31st of July.
31st July.
31st of
Yes.
July.
So
31st July.
So today we are on
22nd.
22nd.
My lord,
So what will happen within 31st?
Lordship
so-
knows not what the
Sorry,
Provident Fund authorities do. So I don't have to
But,
say that.
but Mr.
No.
Mojumdar, you are without any protection from March.
Yes, that's true. That is also
You
true.
are without.
That is also true.
Uh,
My greatest fault was I took over an abandoned garden from the DM's office.
The Asun. The order of the tribe. What is the name of the tribunal?
No, this is Central Government Industrial Tribunal.
Central Government
The
Tribunal.
order of the Central Government Industrial.
Tribunal.
Yes, the order of the Central Government Industrial Tribunal. Order dated policy. The order of the Central Government Industrial Tribunal dated 13/3/2026, 13th of March 2026 in EPF appeal number 22 of 2024 is under challenge at the instance of the establishment.
My lord.
What is the expression? Establishment.
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 At the
Anjuman to
instance of the establishment.
Hmm.
Full stop. By the said order, the establishment was directed, establishment/appellant was directed to directed na kore. By the said order, the operation of the impugned order dated 14th of September 2024 passed under section 14 capital B of the Employees Provident Fund and Miscellaneous Provisions Act 1952 was stayed till the hearing of the appeal on condition that the petitioner deposits 20% of the assessed sum in favor of the respondent authorities within the time limit indicated in the said order. Full stop. Mr. Mojumdar, Lanet Senior Advocate appearing for the petitioner, places reliance upon a decision of the Honorable Supreme Court in the case of HON'BLE Res Laboratory versus Assistant Provident Fund Commercial, reported at 2010 SCC Online SC 1543 in support of his contention that there is no requirement under the statute to deposit the amount awarded under section 14B at the time of preferring an appeal or any portion thereof or any percentage thereof.
Fine.
Full stop. He thus submits that the learned tribunal was not justified in directing the petitioner to deposit the to deposit an amount as a condition for stay, for grant of stay. First up, the learned advocate appearing for the respondent for the Employees Provident Fund Authority seeks an accommodation. Submits that such issue was not raised by the petitioner before the tribunal when the impugned order was passed. First up, taking note of the fact that the matter is coming up, taking note of the fact that 31st of July 2026 has been fixed before the tribunal, this court feels that the interest of justice would be subserved if a liberty is granted to the petitioner to approach the tribunal praying for. Mr. Majumdar, is there any provision for review under the statute before the tribunal?
No.
আচ্ছা কি বললাম if না মিস্টার এটা কি বলে সব শুরু করল হ্যাঁ that the interest of justice would be subserved if the tribunal is directed to revisit the order dated 13th of March 2026 by taking into consideration the judgment of the Honorable Supreme Court in the case of HON'BLE Res Laboratory Supra. First up, for such reason, this court refrains from making any observation as to the applicability of the said decision at this stage, and it will be open to the tribunal to decide the issue strictly in accordance with law. Full stop. Yes, Mr. Majumdar, anything
My lord.
more?
No. The writ petition be disposed of.
Yes, with the above observations and directions, the writ petition stands disposed of.
Only not the order may have to be formally set aside. Or not kept in abeyance, not any some.
I've said revisit that order. Revisit means there is no necessity to set aside then.
Very well.
That is why I have used the expression revisit.
Revisit. Yes, revisit. ভাই তুমি মার্চ থেকে ইন্টারিম অর্ডার নেই তোমার কাছে, কি করে চাইলে? আমি তো খেয়াল করিনি মার্চ থেকে, জজ তো ফাট করে ধরে ফেললো ওটা। আদার সাইড ধরতে পারলো না, জজ ধরতে পারলো না, আমার বেরিয়ে গেল।
Item number 1.
Item number 1, I appear for respondent number
Yes.
5 and 6.
Instance of Lord, not us, probably Lord, respondent number 5.
Yes, because this is an appeal. It has been released and it has been placed. It has been assigned
Yes.
before this bench. Yes, Mr. Dotto, you are appealing for whom?
5 and 6, Millard. Respondent number 5 is the college and 6 is the trust which runs it.
Yes. But the yes, the appellant says that they have not mentioned, it has not come up at their instance. What do you say to
This is,
this?
we have mentioned it. Millard, we had served a letter on the registrar, because if your lordship may kindly have a look to the Millard, the previous order in the past in this appeal, which is dated 2nd of July 2026.
Yes.
Millard, your lordship would find that Millard, first is in paragraph 3, your lordship would find that the learned advocates Millard have sought leave to retire, and then Millard, the leave was granted. And kindly take with paragraph number 7. The paragraph 7 reads, the learned AAAG is directed to obtain a report from the superintendent of police in response to paragraphs, pages 196, 197 and 198 of the stay application. Now, if your lordships may kindly take page 196, where this is a complaint as far back as on 17th of May 2022. Kindly take note page 196 of the application, stay application. Now, Millard, the appellant over here, Millard, he keeps on making complaints to various authorities. Now, this is a complaint of 17th of May 2022. Millard, the primary contention is that, Millard, a property of the trust or removable property, Millard, has been sold at an undervalued price. Please take note paragraph number 4, for example. Please take paragraph 4.
How can it be a subject matter of a writ petition, Mr. Dotto?
Right. That is my point. That is my point. But I am the opposite part. I'm the respondent over here, where the learned single judge, where was pleased to hold exactly what has fallen from the court. That if it is a violation, it is either a violation under the revenue laws or under the Stamp Act, Registration Act, or Millard, the Income Tax Act. So if he wants the deed to be cancelled, Millard, the remedy lies under the Specific Relief Act. He cannot come before the court.
Yes, and
or to the
what the police authorities will do? What the police authorities will do in this?
Right. Now, what did the police do thereafter? Millard, on 2nd of July, Millard, this honorable court, Millard, was pleased to pass an order to take instruction or a report. Now, the police, Millard, registers an FIR, Millard, based on this order of this honorable court. Now, Millard, the FIR, Millard, your lordship may copy. Millard, my learned junior is there, Millard. My junior would, Millard, hand up Millard a copy of the FIR, which was registered on 16th of July. 2nd of June, Millard,
Yes.
the previous bench directs a report to be obtained. 16th of July, Millard, it has to be an FIR was registered. Millard, we filed an SLP. We were compelled to file an SLP, and Millard, in the SLP, Millard, the order of 2nd of July, Millard, has been stayed, and Millard, there is a direction by the Honorable Supreme Court not to, Millard, take any coercive steps. Millard, my learned junior will Millard, hand up, Millard, a copy of the 20th July.
Who is assisting Mr. Dotto?
I'm sorry, Millard.
You are assisting.
Yes.
Yes. Where is the order passed by the Honorable Supreme Court? Now, Mr. Dotto, only one thing. Are you seeking quashing of that FIR?
No, Millard, the quashing of the FIR, Millard, I have to, Millard, take appropriate steps. But, Millard,
Yes.
so far as Millard, the immediate Millard repercussion of an FIR is concerned, Millard, the Honorable Supreme Court has been pleased to Millard protect my client. What I was not
Yes.
suggesting, subject to the business of the court permitting, but this is a matter which requires to be done physically. If your lordship may fix it tomorrow, I can come down and assist your lordship for disposal of this matter. Subject to the business of the court, because your lordships are sitting in two different benches.
Yes, let me hear the appellant, because they were saying that this matter has not come up at their instance.
Right, definitely.
Let us see whether they are interested or not. Let us see that.
But the problem is that the FIR stares at my face. Though the court, the previous benches had only called for a report.
Yes, perhaps they thought that when the report has been called for, they have to show something before the court on the next day, that what steps they have taken pursuant to that direction.
Well, that cannot mean setting the criminal law in motion. When your lordships call for a report, usually the authorities must report back to the court as to the situation prevailing at that point of time, but not aggravate it by registering an FIR.
Yes, what do you say?
Milord, on 2nd of July, Milord, coordinate bench of this Honorable Court directed to call for a report from the state authority. Milord, the order was simply sitter calling for a report as to what steps were taken pursuant to my complaint. Milord, that order was assailed before the Honorable Supreme Court. The Honorable Supreme Court, Milord, this is the order of the Honorable Supreme Court. Milord, we were not there, Milord, only at the admission stage, Milord, this order was passed.
Yes.
Para 2 says there shall be stay of operation of the impugned order until further orders. There shall be no coercive steps being taken against the petitioner till the next date of hearing.
Yes.
So, Milord, so far as the impugned order of calling for report, that is state, Milord, so far the FIR is concerned, they are protected by the order of the Honorable Supreme Court. So, Milord, at present, when the Supreme Court is ceasing of the matter, so, Milord, no further proceedings, Milord, can be done here before this Honorable Court. When the Supreme Court is, they have already approached the Supreme Court. First thing. Second thing, Milord, as my learned senior friend, Milord, has demonstrated the case is not that easy, Milord. This petitioner, Milord, has complained not only for undervaluation of the sale. First of all, Milord, a trust.
Please show us the payers in the writ petition.
Yes.
Yes.
Milord, except the first prayer with respect to investigation,
Please
we
show
have
us
not
the payers in the writ petition. Where is that?
Well, it's at page 35 of the writ petition.
This has been annexed in the stay application.
No, Milord, it's not annexed to the stay application. But I'm told by an affidavit it has been filed later on.
Oh, affidavit. Oh, supplementary affidavit. Yes.
Yes.
Yes, supplementary affidavit, it has been annexed. What are the prayers?
First, Milord, they want, Milord, a special investigating team to look into the affairs of
Milord, except the first prayer with respect to the investigation. Milord, we have not pressed any of the prayers, Milord. This was our first submission before the coordinate bench, Milord, while we are arguing the case before the last circuit bench. So, in respect of the investigation and the criminality of the entire transaction, Milord, we are seeking an independent investigation by the enforcement agencies. Other than that, Milord, we are not pressing any of the reliefs. Milord,
but that was not the submission.
A society. No, that was submitted by us, Milord. I am saying that responsibly.
When you submitted this?
Before the last bench, when the report was called for. This was our submission, that except this prayer, we are not pressing any of the other prayers.
Milord, kindly have a look to, Milord, the order under appeal dated 11th of June 2024. Please have a look to the order.
Coordinate bench on 2nd of July, you said that you have made the submission.
Yes.
But 2nd of July does not record anything with regard to that.
It has not been recorded, but it has been submitted by us.
So we can take note of your submission today also.
Yes.
That you are not pressing any of the reliefs under prayers 7 except prayer A of the writ petition.
My lord.
Yes, Mr. Datta, we can record that for they are not pressing.
But Milord, I am, Milord, on the maintainability of the appeal, Milord, that Milord I intend to, Milord, address your lordship on. Question is, Milord, this gentleman, Milord, there is an order of this Honorable Court, single judge's order of Honorable Justice, kindly permit me to take the name of the Honorable Judge. Honorable Justice Mantha's order is there, Milord, where there is a categoric finding that this gentleman has resigned from, Milord, the college, from the erstwhile management, and that has been accepted. Now, thereafter,
No, Mr. Datta, we will come to only one thing. We will come to that maintainability.
Yes.
But
Yes.
first, they are restricting their appeal to only prayer A. We will consider that after that. Can we now record that they are not pressing anything from the prayers B to other reliefs in the writ petition? How we will
very
be
well, Your
affected
Lordship may
with regard
record
to
that. Yes, when my learned friend says
Because
that, yes,
without relegating the appellant to approach that particular bank for making that, if you are not opposing, then today they are making this submission. Is there any difficulty in recording that?
no, Milord, it is his choice, Milord, to press or give up prayers. Now, if he wants to give up prayers B onwards, but I cannot stand in the way. Therefore, the consideration,
in the alternative, yes, or in the alternative, we can record that he is only pressing his prayer A of the writ petition.
right, and the other prayers he is giving up.
He is giving up the other prayers. So that is one thing. So now, where is the impugned order?
Yes, whether the impugned order is at page, Milord, 183, order under appeal of the stay application, Milord. Well, the purpose, as I can understand, Milord. I'm sorry, Milord.
204.
Order
11th of June 2024.
11th of June 2024. Yes, Milord. Well, there's a long trail of, Milord, litigation. Please take, Milord, paragraph 10 onwards. Our ladyship has been pleased to, Milord, record, Milord, the trail of litigations. Then please come to, Milord, paragraph number 10. Hard learned advocates for the respective parties. This court accepts the contention of Mr. Kaur. Mr. Kaur was appearing, Milord, for NCT. University, I'm sorry. That the university is not a necessary party to this proceeding. It does not deal with imparting of education. Next, whether the society has rightly transferred assets to a trust or whether the sale of land was contrary to law and deed was undervalued are issues which cannot be decided in a writ petition. The taking over of the assets of the trust, constitution of the trust, manner in which the society transferred the property to the trust, and the manner in which the college is functioning under the trust are beyond the scope of judicial review. The further
Now he is
contention of
also
Mr.
giving up
Chatterjee
this prayer.
This prayer.
Now he is giving up this prayer.
Yes. Then the further contention of Mr. Chatterjee so and so did not have any right to continue as such is also a dispute with regard to the internal affairs of the trust. Although Mr. Chatterjee contends that the district magistrate Alipurduar may be directed to make an inquiry into the matter, in my opinion, whether the transfer of the powers of the society along with the assets of the college to the trust was done in a proper and legal manner or not has to be decided in the suit. The prayer for keeping the deed of conveyance in abeyance and a probe into the allegations of undervaluation of the property are matters to be decided by an appropriate forum. Activities of a trust cannot be a subject matter of a writ petition. A mandamus cannot be issued as no legal right of the petitioner has been curtailed by the respondents. At present, the district magistrate also does not have any role to play, liberty to file a suit. Now, Milord, so far as the prayer 1A is concerned, or the first prayer is concerned, this again, Milord, in my very respectful submission, cannot be gone into by the writ court because the fundamentals, as your lordships have held, that a mandamus is available only when a legal right is infringed or threatened to be infringed, where there is a corresponding legal duty. There your lordships will not exercise your right of issuing mandamus for redressal of the grievances. Now, my
Yes,
society.
commanding the enforcement of the legal duties.
Right. First is right. First is there has to be a right.
Yes.
Now, if that
Yes.
right is infringed, now, my lord, with respect, today, my lord, this gentleman, my lord, is no one of the society. Now, whether, my lord, he can file a writ petition, for filing a writ petition, he has to show that his so-and-so legal cannot go before the court and will not point out fingers at will not the running of administration of any college, any institute, any other bodies. It is true that he at one point of time was over here, but at a later point of time, he has left it. Now, if your lordship kindly have a look to honorable
Only
Justice
one thing,
Martha's
Mr.
order.
Dotto.
Yes.
Mr. Dotto, only one thing.
Yes.
As the learned advocate for the appellant is pointing out that an interlocutory order passed in this appeal is now pending before the, against that SLP is pending before the Honorable Supreme Court.
Yes.
Now, at this stage, if the main proceedings is disposed of,
Yes.
can it be done now? Because when that an interlocutory order against that or SLP is pending, what do you say to this?
Millard, my respectful submission would be, my very respectful submission would be, Millard, the Honorable Supreme Court.
Because you are protected.
Yes, yes.
You are
At
protected now.
Right, right. Now, Millard, my respectful submission would be on the legal aspect. That, Millard, the
Yes.
SLP, during its final consideration, the Honorable Supreme Court will consider whether the 2nd of July order is a right order or a wrong order. Where the Honorable Supreme Court, Millard, could have, Millard, stayed all the proceedings before this court, but the Honorable Supreme Court was pleased not to stay the proceedings. Therefore, Millard, simply
No,
because
yes,
the,
that is.
yes, simply because
yes,
the proceeding is
but the-
pending before the higher court, Millard, I don't think we are
Yes.
subject to correction again, Millard, that your lordships should stay your lordship's hands in this regard. Because I'll tell you,
No,
lordship, Millard,
yes,
these have, Millard,
only-
these have, Millard, very cascading effect, which, Millard,
Yes.
ultimately, Millard, is suffered by the student community at large. But here, Millard, people keep on fighting, pointing fingers at each other, this, that, etc. But ultimately, the reputation of the institute goes to, Millard, the gallows. Where my students will not come to me. Millard, there are allegations against this
But
gentleman that,
Mr.
Millard, he
Dotto,
had.
is there?
Yes, Millard.
Can both of you not settle? What is the dispute? Can you not settle amongst yourself for the benefit of the students?
Millard, I have spoken to Millard,
Because
my
as you have
client,
rightly said, that the
Yes.
students' interest you are
Right,
concerned.
The issue is not of settlement here.
So, can you?
Millard, first is Millard, I had spoken on this aspect also. Millard,
Yes.
the contention of our client is that if he is an outsider, why should we sit with him at all? With the entire, then we have to sit with anybody who comes and raises fingers.
He's not at all outside.
No, that's one way, Mr. Dotto, that's one way of looking at it. But since you have said that these litigations are going on and the students' interest may suffer one way or
Yes.
the other.
Well,
So
what-
some impressions.
Well, kindly, Millard, to Millard, dispel some doubt from the mind of the court, please have a look to Millard, Justice Martha's order at page 54, where this order has not been appealed against.
Page
54. But this is dated 11/11/2019. Millard, I'll skip over, Millard, the irrelevant parts. Please come to Millard, page 55, the third paragraph. The principal dispute was started with one Sajol Sarkar, he's the appellant, who was an elected president of the college as nominated by the governing body and as elected by the members of the governing body of the college. The said Sajol Sarkar resigned with effect from 1st August 2018 that was accepted unanimously by the governing body. In terms of the bylaws of the society, the secretary of the society is required to represent the college as also the society before any public or private forum. Now, this is the dispute which his lordship record. Now, the findings of his lordship, Millard, your lordship will find at page 56. The fourth paragraph at page 56. A further development is stated to have occurred in repetitional number, etc., where a coordinate bench of this court found that Sri Sajal Sarkar, while claiming to be the president of the college, had obtained, kindly see what he is doing to the students, obtained mark sheets of about 200 students from the university and had taken the same in his custody. It is alleged by the petitioners in so and so that when the petitioner was tracing the mark sheet of the student, the said Sajal Sarkar was selling the mark sheets to the students and third parties. The same is denied by Sajal Sarkar. Now kindly take page 57, the third paragraph. Now, this is the conduct of this gentleman. Where at page 57,
Yes.
a large number of arguments and counter arguments have been raised, which this court does not deem necessary to go into at this stage. This court feels that the interest of the students and their career is primary and above all. Personal rivalries and egos between the present managing committee and the secretary of the said Sajal Sarkar is a secondary dispute. In view of, this is the last finding of his lordship. In view of the resolution of the governing body of the college dated 1st of August 2018, this court is compelled to accept that Sajal Sarkar has in fact resigned from the post of president of the college. We had no appeal against this finding. And this gentleman keeps on complaining every month to various authorities on various aspects of the college. And we are kindly see what is the final Miller direction of his lordship at page 59, the second paragraph. It is made clear that till such time, the matter was delegated to the registrar also, we have to look into the affairs. Till such time, the decision is taken by the registrar as directed herein above, and if necessary, DM Alipurduar, the said Sajal Sarkar shall not interfere with the functioning of the college and shall not represent the college before any fora whatsoever. Number, this has attained finally.
What happened before the registrar?
Number,
What happened before the registrar?
the registrar will directed elections to be conducted. Yes, subsequently.
The subsequent order.
860.
Millard, your lordship, kindly take me to the next page, Millard, which is page 60.
Last one. In view of the above.
But here, Millard, Sajal Sarkar was represented and heard. That is recorded in the first paragraph. Now, please take me the last 5 lines of that page. In view of the above observation, the undersigned is of the view that a fresh election may be held following the constitution of the college, if already framed by the parent body. Parent body. Otherwise, the college should follow the constitution of the university under which it is affiliated.
Election held.
He has challenged. The repetition.
No, but this again was challenged by him. But this year, lordship will find page
147.
ওটা ছিল
ওটা নেই, ওটা নেই।
Oh, Miller, I think that
SLP, that is the SLP.
but that is not there. Miller, this was again challenged by the Sarkar.
But elections.
Therefore,
not
Miller,
yet
my
held.
respectful submission would be
Elections
I
not
take
held.
instruction.
Not yet held.
That.
Yes.
Not one side.
But I'll take instruction on that. But I'm a new entrant in this matter. Only yes. No.
You
I
are
have
a new entrant.
got, this is the.
You are a new
This
entrant.
is the
Mr.
minute
Bhakto.
only to. Yes, yesterday evening entrant. So
This
I
is one
was
aspect,
praying,
one
Millard, kindly
perspective.
fix it, Millard, if possible tomorrow, so that Millard, we can go and show your lordship. This will take some time. So this will take some time, and I need to
First
take
of all-
a number of documents.
First of all, Milord, since the Honorable Supreme Court is decision of the matter, Milord, it is our submission before this Honorable Court that it would not be prudent to proceed with the matter by the Honorable High Court. My first submission. Second, my lord, my learned senior friend has very categorically, my lord, picked certain parts from the case, my lord, and has demonstrated his case. Now, my lord, from my side,
Without
my lord, 2018
without interjecting, my learned friend, I have only referred to those parts which I felt is required at this stage. I am yet to, Milord, take your lordship through all the documents which goes against my learned friend's line.
very well, very well, very well. Lord, yes,
Yes,
Lord, 2018. Lord,
when do you want to come back?
Lord, since
Lord,
the
if
Supreme
possible-
Court is matter is pending, Lord, let it be taken up after the Supreme Court decides the matter. We have
No,
already
no.
appeared there. We have filed our wakalatnama
Milord, the
today.
FIR is hanging
No,
on my
the
head.
proceedings has not been stayed. Only
Proceeding has not been stayed,
then-
but the genesis of the order.
what is
Second,
the genesis? Genesis of the order is with regard to a police complaint.
yes,
Police complaint, that's a different thing altogether. But the issue is now, you are saying that you are giving up all other points.
yes, I am praying for police
So
investigation.
only prayer A, that will be considered. However it is maintainable, how far it can be gone into under Article 226. These are the issues.
Milord, we say, Milord, that unless Supreme Court decides the issue, Milord, it would not be prudent, Milord, to proceed with this proceeding here before the High Court. But this is our submission. Because Supreme Court is considering it, the 2nd July order, Milord, is the base on which, Milord, the state has actually acted. Because prior to that, no, nothing was done. Why nothing was done, Milord, we will demonstrate before this honorable court. So, Milord,
Milord,
at this
I will
stage, Milord,
demonstrate,
when
Milord.
Sir, please, sir, I did not
I'm
speak a
sorry.
single word.
I'm sorry.
Please.
I'm sorry. I'm sorry. I'm sorry.
When the Honorable Supreme Court, Milord, is sitting of the matter, is considering the entire case in toto, Milord, let the Honorable Supreme Court decide first whether the legality of the 2nd July order. It was a simpliciter on order, Milord, calling for a report. And that report was challenged. You do not know, Milord, what has transpired in the Supreme Court during the hearing. Now, Milord, we'll go there, we'll place our case before the Honorable Supreme Court. Let the Supreme Court take up the matter, decide it. And then, Milord, this Honorable Court will proceed further.
Only one thing, Mr. Dotto,
Yes,
nothing is affecting your rights now. The writ petition has been dismissed.
Milord, I'll tell you, Lordship, Milord. First problem is, well, what did the police do? The police called Milord.
That issue is pending.
No.
That issue is pending before the Honorable Supreme
sentence.
Court.
Wait, one sentence. Milord, the police calls Milord the appellate and gets that 2022 letter, 17th May 2022 letter re-signed by him with a date of July 2026 and registers the FIR. And thereafter, Milord, which compelled me to go before the Supreme Court. Now, the Supreme Court, Milord,
Yes.
in its wisdom, Milord felt that I should be protected in respect of the FIR, but at the same
Yes.
time, the Supreme Court was also of the view that the proceedings before this honorable court need not be stayed. Therefore, Milord, in my very respectful submission, there is no bar for this court to, Milord, go into the matter. Number one. Number two is, Milord, at the end of the litigation, before the Supreme Court, either the 2nd July order will remain or the 2nd July order will not remain.
Yes.
The second
Yes.
2nd July order is only, Milord, calling for a report, and we find that the police oversteps and Milord initiates a criminal proceeding against me. Therefore, Milord, what I respectfully submit is, Milord, your Lordship may hear out, Milord, the appeal in respect of prayer A, as my learned friend, since my learned friend has given up the other prayers, and consider it. I don't think, Milord, that will in any way impinge upon, Milord, the proceeding which is pending before the Honorable Supreme Court. It was only an order calling for a report.
Yes, please.
Yes.
Lord, Lord, I'll just say one thing, Lord. Lord, if your lordship decides to take up this matter, Lord, two things. Either your lordship allows it or your lordship dismiss it. Lord, if your lordship allows the application, Lord, then there is a stay of the Honorable Supreme Court with respect to the 2nd
We
July
will
order.
consider that. We are keeping it on Tuesday. We are not passing, we are keeping it on Tuesday.
Very well.
Keeping it on Tuesday. Mr. Datta, Tuesday?
Very well, my lord. I'll make an attempt to be physically present. Because this is
No,
a
you
matter.
said-
No. Please. You can keep your
No,
lordship
2
may keep
PM
it on
will
Tuesday.
be, you wanted to appear physically. So 2 PM next, because it has to be on 2 PM.
Yes. Your lordship will be breaking from two different benches. Yeah, please keep it at 2.
Yes.
Please keep it at 2.
On
But
behalf
in
of
the
the state,
meantime,
my lord, the
Lord-
report is ready. We will-
Yes.
Opposition.
Yes, Mr. Datta, in the meantime, what?
But in the meantime, you kindly permit me to file an opposition, my lord, subject to your lordship's consideration.
My lord,
To
then
the-
we have
to
to
the-
file, my lord, reply.
Okay.
No, opposition
I
to
am for the
what?
appellant.
The stay application, my lord.
Opposition to what?
Lordship, this appeal,
Very
opposition
well,
to
very
this
well.
appeal.
No, opposition to what?
Stay.
Stay application, Mr. Datta, there is nothing. I can dispose of the stay application here and now.
Very well,
Petition
very well.
dismissed, there is no question
Very-
of stay.
Very well.
There is no question of stay.
Very well.
Where is the question of stay?
Right.
We
Yes.
are not praying for stay even. Lord.
Ashok.
Very well.
The state is ready with the report. We will submit on Tuesday. The state is ready with the report. We will submit on Tuesday.
Can 1 of 2024, this is an application for stay of operation of stay of operation of the impugned judgment and order dated 11th of June 2024, passed in WPA 288 of 2024. Since by the impugned judgment and order, the writ petitions to dismiss, there is no question of passing any since the writ petition stood dismissed, there is no question of enforcement of the said order. Therefore, the question of passing any order of stay does not arise. Can 1 of
We
2024.
have not prayed for even stay.
You have filed this application.
Yes, but we are not praying. We
We are
not
disposing of that. At this stage, the learned advocate applying.
for the convenience of the court, because all the documents are annexed in this.
The learned at this stage, the learned advocate appealing for the petitioner submits that the petitioner is also not paying for an order of stay of operation of the impugned judgment. Accordingly, can 1 of 2024 stands disposed of. However, the records pertaining to can 1 of 2024 shall be retained along with the records of this appeal, as all the documents have been annexed to the said application. এবারে Yes, but Mr. Datta, only one thing is there. The
Yes,
order
Milord.
which was passed on 2nd of July was on CAN
Yes, Milord.
also.
I see.
Then I think
There-
cannot
yes,
be
yes, yes.
disposed of.
Very well.
Should have pointed out on that date, Mr. Datta. So there's no question of any stay.
I did not appear
On
on
that-
the last occasion, Milord. But this is
Maybe
my
you
first
are not
appearance in
there,
this
your
matter.
counterpart was there.
Right. No, because your lordship will find out on that day, the lawyers were caught unaware. They had to retire from the matter.
আচ্ছা তাহলে এটাকে কেটে দিন হ্যাঁ পুরোটাই কেটে দিন Mr. Datta, learned advocate, appears for the appellant. First up, he submits that considering the issues involved in this appeal, he wants to address the court physically. First up, paragraph. The learned advocate appearing for the appellant submits that since the matter is since an SLP is pending against an order dated 2nd of July 2026 passed by a coordinate bench in Can 1 of 2024 arising out of MAT 64 of 2024. The hearing of this appeal should be adjourned till the matter is decided by the Honorable Supreme Court. First up, such issue shall be considered by this court in the next hearing. First up, list this matter on 2nd of 28th of July 2026 at 2 p.m.
One line on behalf of the state.
Yes, your submission has to be recorded. Mr. Mistro, learned assistant additional advocate general, submits that you have got the instructions.
Yes, ma'am. The report is ready. As per the last order of the court, the report is ready. We will
Files the copy of the file it. File the report, circulate to the parties.
I will do that. It's actually more in the nature of an, I mean, it is a letter addressed to me.
Oh.
Attorney client.
Submits that the report will be ready on the next day.
All the action that has been taken by all the authorities is there.
State is represented by Mr. Mistro, learned assistant additional advocate general.
Milord, is it your lordship's pleasure? Is it my lord's pleasure to record that my learned friend gives up, Milord, the other prayers except prayer A of the writ petition?
Yes. তাহলে একটা লিখে দিন when this matter is taken up for hearing, the learned advocate appearing for the appellant draws the attention of the court to the reliefs claimed in the writ petition and submits that the petitioner, that the appellant is only pressing his claim insofar as the relief claimed under prayer A of the writ petition is concerned. First up, the appellant shall not press his claim insofar as the other reliefs claimed in the writ petition is concerned. First of such submission of the learned advocate for the appellant is placed on record.
This was also made earlier before the earlier court.
If we record that, then you have to go before that bench to say that yes, this submission was made, that was not recorded.
In presence of all the parties, we had made this submission.
Without we are recording today, you are making that submission. Mr. Dotto is not raising any objection with regard to that. So that we are recording, because if we go by that, then you have to go file a review of that order. It will be difficult because that's of 2nd of July. Of that order, it might be also difficult.
I'm so grateful, man.
Thank you.
I'm grateful.
Yes, for the list. Yes. Overdrawal.
Cover letter, the date is fixed 24th, Lordship, but we need some time for instruction, Lordship.
24th is the date.
Yes, Lordship.
All right. List this matter. 24th the date kore din. 24th.
Lordship, next week, Lordship, because we need instruction in this case, Lordship.
From where are you saying that it's 24th?
In our cover letter, Lordship. Cover letter, the date has written is 24th September.
Yes, madam. Here you are mentioning 22nd, and in the copy which you are serving, you have mentioned 24th. Only 24th rekha din. But you have served, so 24th. Order. Should 24th order. Yes, next.
কালকে আবার থাকবে
Yes. Don't you have those similar orders?
Yes.
So next day, tomorrow. Yes, please bring those orders. Yes.
Grateful.
All same. Not today kore rakhun. 367 not today kore rakhun. Please come tomorrow with those orders. Yes, call the next matter.
58.
68, yes.
58. 58 na.
Sixty-eight, yes.
60.
Yes, who is for, yes, you are for the petitioner. Where is Mr. Dhar? Yes. Where is Mr. Dhar?
He is in court, Lordship.
Pass over. Yes. Call the next matter. 69, yes.
For the state.
Yes. You are for the respondent number?
School Service Commission, my lord, is the answering.
School Service Commission.
5 and 6, 5th and 6th.
Yes.
Respondent, they are the answering.
Yes, yes. What is this matter?
What is that?
Naam ka de- Give the name.
I don't.
What is this?
Hello. Appear before the Apatharani selection.
Yes.
Documentation and implementation I got in the group of bioscience. I mean, not speaking also clear. There are produced there, the documents of the taken and asking for information also. As per the page 57, my lord.
Yes. Yes.
Serial number 207.
You are in serial number 307. Yes.
I been selected by the Secretary of Postcode Regional School Service Commission on 26/9/2024. And publishes list payment of successful candidates, as I have already mentioned to you, sir. And now that I have been asked to appear before the school that is selected by the high of college school, government school, page number 68 of my school.
Yes.
With that, and I was directed to this my whole function is and the one of this. I placed it. And thereafter, they gave me just 15 days time by mentioning that we have to join within 15 days. I couldn't join during this period, although it's practically as per the rules of the School Service Commission, it's a C. They should give it that 15 days time. So the time was 30 days. As I mentioned, page number 61. Page number 61. Yes, I have to open my sorry that it is 15 days because my mother was sick. I couldn't practically bypass my mother business and go for joining and I later. This is my condition.
Where is that letter?
That letter is there. Page number 94.
94.
That is here then.
94 is the order of the 93. This letter was issued when? 10th of February 20. Yes.
Hello. I'm going to the letter. Page 93, madam.
Yes.
Respected sir. The chairman West Bengal School Service Commission. Okay, yes, sudden law, the law secretary, solved it. I will pay us for joining. I would like to draw your attention. I see someone want to something address, such and such my opponent letter.
Yes, what do you say? Who is for the School Service Commission? You are for the School Service Commission. Yes, what do you say? But now is the School Service Commission is the who appears for School Service Commission.
My lord.
He appeared.
Usually appears.
Used to. He appeared.
Even last.
Our lordship, Mr. Sina was there and I got an earlier order my lord. That is page number.
Because School Service Commission is required at page 96, there is the reasoned order.
Reasoned order, that is a different thing, but I want to.
So that in the absence of School Service Commission, my lord.
My lord. My learned friend, please follow me, that is under challenge. And practically, the order passed by her lordship, that is page number 94. Page 94. Page 94. Page 94.
এটাই তো consider হয়েছে।
Then what happened by the commission? It was the direction passed to consider the representation.
Yes.
Then what happened?
Nothing, this is, give any reply, and practically, then
19.1, my lord, page 96 seems to be that decision. Yes, my lord, kindly see page 96, it starts with reasoned order in connection with WPA 1781 of 2025 in compliance with the solemn order dated 16th of December 2025. On 16th of December 2025, the Honorable Justice Amrita Sinha directed, and this is the reasoned order.
order, there is so, but they have bypassed the entire order passed by the Her Lordship. My lord.
No,
They have
the
not-
coordinate bench only directed to consider.
Yes.
So consideration does not mean to allow. So, yes, so now the commission has passed a reasoned order.
Yes, my lord.
There is page 95.
Yeah, 96.
Page 95, what are they saying? If required, the petitioner may be directed to submit relevant documents in support of his prayer.
If required, they did not feel it required.
Yes.
But the reason order they have said, I will then go through the reason order, my lord. As far state is there, but I want to see there, and my argument is there.
But who is appearing for school service?
School Service
now?
Commission nowadays, এখন কে appear করছে রে? জানি।
Last circuit.
Last circuit, what I have been told, my lord, Mr. Shumit Kumar Roy had appeared.
No, no.
Last circuit, and another matter.
Sutanu Patra.
No, Dr. Sutanu Patso was appearing
Previously, yes.
Now, I think Dr. Patso is not appearing in school service commission matters.
Camera has been checked.
Yes, so now Mr. Rai is appearing.
That I have been told by my learned co-counsel in another matter in the last circuit, my lord.
Now, what can be done now?
I want to get the order passed by Her Lordship that there is, in this case, it is respondent 5 and 6 as per my opinion. I want to get their answer because 2 to 4.
That answer has been given here.
That is reason order. I want to argue with this reason order. Reason order
Then-
is not final, my lord. And I am challenging this reason order. They are passed.
All right, then it is to be heard finally.
Yes, my lord.
There is no question of any interim order. The petitioner has challenged the reasoned order passed by the chairman, West Bengal Central School Service Commission, rejecting the prayer.
My lord, one thing, they have not given me any opportunities for hearing. As it was written there mentioned in Her Lordship order.
Rejecting the prayer of the petitioner. Full stop. None appears for the School Service Commission. Full stop. Petitioner is directed to communicate this order to the non-appearing respondents and file an affidavit of service on the next date. Full stop. Let affidavit in opposition be filed within 3 weeks from date. Full stop. Reply thereto, comma, if any, comma, be filed within a week thereafter. Full stop. Parties will be at liberty to mention this matter for enlistment under the hearing after the expiry of the period fixed for exchange of affidavits. Yes, next.
Grateful, my lord. No, wait.
Yes, 70. Yes, who is appearing?
From 1988 to 2023, we can unblend this record subsequently.
You have received instructions. Yes.
Lordship, this petitioner is was caught red-handed.
Petitioner is,
Caught
please use the
red-handed.
microphone.
Caught red-handed, Lordship. In the office hours, Lordship, he has stolen some iron from the site, Lordship. Subsequently, one FIR has lodged, but somehow he has found not guilty, Lordship. But the order was passed in the year 2025 in June. After that, Lordship, the department has written several communication to the different authorities for filing appeal, Lordship. Now this case has assigned to the public prosecutor Jalpaiguri for filing appeal, Lordship, because otherwise this will fix a wrong precedent. He was caught red-handed. Again, if you reinstate in the service, Lordship, it will be
But this order was passed when?
12 June 2026, 2025.
12 June
Lordship, 1 minute,
2025.
Lordship.
So the period of limitation is over.
Already over, my lord.
No, Lordship, but there is sufficient ground for
Yes, my lord, they have been rejected. If your lordship give me permission, my lord. May I, my lord?
কবে পাস হয়েছিল অর্ডারটা কবে পাস হচ্ছিল অর্ডারটা
My lord, kindly comes to page number 23 once.
yes 12th June 2025 lordship order was passed
Page number 23 once. The decisions with reasons, my lord. My lord, the PW1.
You are getting subsistence allowance.
50%
So,
lordship 50% lordship
He is
No, lord,
getting.
getting lordship. On instruction I am submitting lordship, he is getting 50% lordship. Lordship, I have thorough report lordship from 21st June 2025 lordship. The department has
Have
given
you
the
initiated any disciplinary proceedings?
no lordship.
Why?
That was the mistake on part of my department, lordship. But now the officer has given this information, lordship. He has given his best to file an appeal, lordship. Lordship, I have the thorough report, lordship, with me. Several correspondence before all the
All right,
authorities.
then
lordship.
file a report.
Yes, lordship.
The petitioner has prayed for reinstatement in service on the ground
Matter.
that the petitioner has been acquitted in the criminal case. So stop, Ms. Singh Lanet,
Junior government leader.
junior government pleader, submits that she has received instructions that an appeal is expected to be filed against the order passed by the criminal court shortly. Stop. Let a report in the form of an affidavit be filed by the who shall file? This is which department?
Government of West Bengal executive engineer. lordship.
Executive engineer, Public Works Department, Jalpaiguri, being the sixth respondent within 3 weeks from date.
Great, lordship.
List this matter before the next available circuit bench. Yes, next.
Item number 71.
Lordship, item number 71, I am for the GTA, lordship.
Yes, who is for the petitioner?
Mr. Devosridhar is Devosri. Oh,
Yes.
Samina Lava.
This happens when you have so many briefs, Mr. Dor. Petitioner, respondent.
50% of the matter in the corpus belongs to him.
50?
50%.
My estimation is above 50.
My lordship is
That's my
always right.
calculation.
আজকের তারিখ কত?
Yes, Mr. Dor.
This matter happens to be a regularization matter of GTA voluntary teacher. Now there is a checkered history, my lords, and some of these appeals are also pending before the Honorable Division Bench. So no purpose would be served today, my lords, by arguing this matter. That is my small contention subject to whatever my learned friend Mr. Dhar says.
Already there are some
Thank you.
tuition bills also. If I take the lordship to the last order passed by the budget,
Show me the orders which are against you.
all are in favor of him. All are in my favor.
No,
All are in my favor.
no, sir.
If your lordship, I take the last order, I have annexed at page 172, annexed at P9.
Yes.
Last order where everything has been considered. All the earlier judgments of the division we consider this one. If your lordship kindly come to directly of the page number 216. The operative portion, last paragraph number 21. Page number 216.
216, yes.
I find that in the instant if the petitioners claim to be working on temporary basis, volunteering sanction package post, the said stand of the petitioners is to be tested in the sense that final inquiry in this regard may be necessary for being undertaken by the CTA. However, having regard to the judgments delivered in Ajay Kumar Kharka and the judgment delivered by the cabinet bench in the case of Kishan Rai and Wangal Lepcha, in my view, the respondents having regularized the appointment of other similarly placed candidates, such benefit cannot be denied to the petitioners if on scrutiny it appears that the petitioners are similarly placed. For the same purpose, I am of the view that GTA Education Department must ensure the number of sanctioned permanent posts which have already been sanctioned in respect of the schools.
Against this, an appeal is pending.
My lordship, now that my lords, the argument has started, I can say a couple of things, my lords. This, my lordship, in our humble submission, lords, happens to be illegal appointments. Illegal appointments. So this is not irregular appointment. My lords will recollect from Uma Devi to Jago to Ilmo Devi what the law on the subject is. I will come to that, my lords. What has happened in these cases, my lords, is that there was some political unrest that was there in the district of Darjeeling. Because of that unrest, recruitment of teachers couldn't be done. Now, these incumbents who are all here, they are all voluntary teacher. Now, what is the meaning of a voluntary teacher? The meaning of a voluntary teacher, my lordship, is that they approached the nearest political leader that was there or the chairman of the board and they requested him that I am unemployed, please give me some job. And in Nepali, there is a saying that says that tapai hamro manchi ho, boli padki aunus, math paraunus. So you come tomorrow and start teaching math. So this is the recruitment process. Now, in my humble submission, lords, this recruitment process is unknown to the constitution or to the recruitment rules. On top of everything, lords, they are voluntary teacher. So it is presumed that they have given their service gratuitously. Tomorrow, if I go plant a tree in the circuit bench premises, lords, I cannot charge a fees for that. They definitely deserve a medal for whatever they have done. But regularization, how can that be done? That, lords, is my second submission. Third and most important of everything is, my lords, that we have done an inquiry into the matter. If I can have my lordship for a moment on the inquiry report, and then I will come to the relevant judgments. Lord, this is a letter that has been addressed to the Principal Secretary by the Additional Chief Secretary. This is 9th of June 2026. Now, obviously, when the coordinate bench order that has been passed and relied upon by my learned friend, then this report was not there before the coordinate bench. Therefore, the coordinate bench couldn't have taken note of the fact of the situation. We say, my lords, that these are all illegal appointments. There had been, at the first instance, my lords, there had been in total, it goes in seriatim, my lords, 2 people were allowed, thereafter 4 were allowed, thereafter 6 were allowed, another 4 were allowed, another 3 were allowed, 15 were allowed.
Inquiry report, the petitioners' names are appearing.
No, this is in respect of voluntary teachers who have already, by way of approaching the court, have seek regularization, and their regularization has also been done. We are collectively challenging it before the Honorable Division Bench. Not this person has never, he is approaching first time for the regularization here. My contention today, my lords, is that if I can have my lordship for a moment on what the law on the subject is. My
Only
lordship
one
knows
thing,
better than
Mr. Dhar, please show your initial appointment letter.
Oh, that is not there. Boli parki aunus, math paraunus. Come tomorrow morning, start teaching math.
Please show me your initial appointment letter.
Paragraph number 6, I have stated that the petitioners were appointed on the basis of resolutions adopted by the managing committee.
So no advertisement, no competitive exam, nothing happening. These are public employment, purportedly.
Where is the pay slip?
Oh, nothing. They are paid from the school fund. The maximum fees as
Where
per
is the
government
pay
is
slip?
250 rupees. The school is collecting 1150 rupees and they are getting paid for the
What is the
gratuitous
process
service.
that was followed for your appointment?
The managing committee of the school took a resolution.
No advertisement,
Nothing.
no selection process.
No approval, no
nothing.
sanction. No sanction.
Were you appointed against sanction
I was
posts?
appointed as a sanction.
Please show me that you were appointed against sanction posts. Please show me that.
I've pleaded in my relevant paragraph.
Where? Please show me the process of selection that you have pleaded.
Number 5, the petitioners were appointed as full-time voluntary assistant teachers of various schools against sanctioned posts.
This is an illegal appointment, Mr. Dhar, not an irregular appointment as rightly said.
But they have to prove that this is, they have to prove.
Your statement shows. You have not pleaded anything. What was the process?
The government never appoints voluntary teachers.
Cannot be.
It is not known in law.
Appointed on the basis of resolution. Letters, then director of school committee.
By resolutions, appointment cannot be done if it is not followed the process. Cannot be done. Have you got Uma Devi? Cannot be done.
But Lordship, pursuant to judgment judgments, many of they have been regularized.
That
is under
are
check.
not there.
That is an under
Negative
challenge.
equality you cannot claim.
Equality does not place in negativity.
Cannot claim. Merely because some illegal appointments have been made. It's difficult, Mr. Dhar.
Then let me take discussion from the facts if they have the office of the, if they have the relevant documents of
The first judgment
You have
that I would be relying upon
You have
today,
to
Milord, says
then change your entire writ petition. Petition does not say so. If that would be have to be your case, you have to frame your writ petition in a different line, Mr. Dhar, altogether. You have started by saying pursuant to the resolutions. Cannot be done in that way. That's the distinction between illegal and irregular.
But kindly appreciate no recruitment process was followed by no. The West Bengal School Service Commission Act was not made applicable in the Hill region.
today there is no recruitment for judges of the High Court. So somebody will go and sit and pass orders.
What step they have taken till date?
Voluntarily, voluntary judge.
Sir, till date they have not challenged my appointment. Today morning
No,
also.
they are not challenging your appointment, but they are challenging the regularization. They are not challenging your appointment. You continue as you are.
Voluntarily.
Now, if they have filed an appeal, let the servers of copy. You have filed an appeal against this order.
No. You are coming here for regularization first. For those who are regularized, we are preferring appeal.
Then I have to wait for the order of the
All in the same school.
No, different school throughout. 413.
How can it be a joint writ petition?
413 writ petitions.
How can that be a joint cause of action, Mr. Dhar? Appointments at different point of time in different schools. How can it be a joint cause of action? How much court fees you have paid, Mr. Dhar? How many? Then put in the balance court fees. Then I will call for affidavits. Otherwise, it will be dismissed here and now.
Yes, court fees will be put in the course of the
In course of?
today.
Thank you. Ashwin. Only 12.
No.
The total lot happens to be 438.
438.
Voluntary teachers are there.
But here 12.
Here 12, sir. 12, sir.
Mr. Dhar, learned advocate, appealing for the petitioner submits that the deficit court fees shall be put in course of by tomorrow. By tomorrow, first up, the petitioners have prayed for. A direction upon the respondent authorities to grant approval to the appointment of the petitioners as full-time assistant teachers against the sanctioned post in their respective schools. Full stop. The learned assistant additional advocate general submits that in the meantime, an inquiry has been conducted and it has been found that voluntary teachers have been appointed illegally without following due process of appointment. To stop, paragraph, let affidavit in opposition be filed within by the respondents within 4 weeks from date. To stop, reply thereto, if any, be filed within 2 weeks thereafter. To stop, parties will be at liberty to mention this matter for enlistment under the heading hearing after the expiry of the period fixed for exchange of affidavits.
I am so deeply obliged.
It is however made clear that if the deficit court fees is not paid within the time limit indicated hearing before, the writ petition shall stand dismissed insofar as the petitioners numbers 2 to 12 are concerned. So only it will be against one. Yes, GTA is the party.
Yes, GTA is the
Who is appealing for? You are appealing for GTA. Yes, you are supporting or opposing?
I'm supporting the state lordship.
Previously, they were in a state of dilemma. Now, after the change of dispensation, they are supporting the state.
Earlier also we have supported the state lordship because all the appointments were somehow through the state lordship because the state is the actual stakeholder because the fund has to come from the state lordship. So if a state will regularize, then we have no objection. If not, because the school service.
So you have no objection?
No lordship. In any matter we have
If
no.
it is regularized, you have no objection. If it is not regularized, then also you have nothing to say.
Yes, lordship, because the school service commission is not functioning. The school has to run lordship.
Next.
Order 72. I beg to appear for the petition.
Yes.
On last occasion, your lordship has directed us to come back with regard to the maintainability of this petition in view of section 21A of the Banking Regulation Act 1949. Lord, may I place reliance on the same judgment which my learned friend on the last occasion has relied on? Considering.
Prior to that, please kindly come. What is your challenge in this writ petition?
Yes, my lord. I have complained regarding certain irregularities to the banking.
No, this is that matter. Outstanding dues have been paid. When have you paid? Please show me. When have you paid? And did you reserve your right to challenge at the time of paying? Please show me that first.
Yes, madam. Kindly takes up. Why I have paid? On last occasion also, your lordship has posed me this question. Why I have paid? Kindly takes up. Page 39, my lord. This is the sanction letter.
Yes.
It's a part of the sanction letter.
No, I'm not asking you why you have paid. I'm only asking you, did you reserve your right to challenge? Please show me that document. When you have paid the outstanding, please show me that you have reserved your right to challenge.
My lord, when the payment is made in lieu of demand raised under section 13(2) of the SurfaceI Act, my lord, there is no scope to, my lord.
Then there is no scope to challenge, sir.
My lord, kindly.
Then there is no scope to challenge. Then there is no scope to challenge.
My lord, kindly.
After taking the benefit of that, you cannot now challenge.
My lord, kindly takes up page 107 and 110.
Yes.
In particularly 110, man.
110.
110.
110 is not there. Last page is 109 in my copy.
There are two volumes.
There are, oh, sorry. Yes, 110, second volume. Yes.
Yes, my lord. My lord, this is the letter which we have submitted after making the payment, my lord. Now, my lord, now may I take your lordship, because I have been agitating before the bank authorities since from the year 2023. Kindly see, it takes up page 111 and 113 after 110. 111 and 113. I have made a comprehensive representation. At the time of sanction of the loan, they said that 8.35 NCLR plus 1.85 spread will be chargeable as interest. Now I detected they are charging me 14.90%. After I detected, since from kindly see the date, 16 June.
Facts that we gone into in Article 226.
But kindly allow me, man. Kindly allow me. Kindly take up page 39, my lord.
This fact be decided in the written
Yes, my lord.
petition?
Yes, my lord. Kindly allow me, my lord. They have done something which they could not have done. Now, my lord, kindly takes up page 41. Annexed E, my lord. My lord.
Then let them file affidavits.
Obliged. There is no scope of interim relief, my lord.
My lords, 30 seconds again. If my lords, please.
File your affidavits.
My lords, 30
The
seconds.
point of mental I am keeping it open.
My lords, I'm just submitting. Today itself, it might be decided, lordships. Even affidavits are not required. So may I please, my lords, for 30 seconds again. Today itself. So far, my little understanding goes, and I am better turning. I have been strictly advised to follow the pollution board rules. 65 decibel and low. I better turn on the volume. So far, my little understanding was, my lords, only two questions were raised by this honorable court. What is the locus after paying the entire dues? Whether they have reserved their rights. Only two questions, nothing more. Apparently, my senior brother has failed to address both of them. All two. Why affidavit is required? Now, my lords, kindly see. They have cited one citation of the Honorable Calcutta High Court that is decided in 2022 by division bench. Kindly see. That is BMW Industries, my lord. That is before his lordship for kind consideration, lordship.
Yes.
Kindly come to the paragraph number 8. I am only placing their citation. I will come to mine later.
Yes.
Paragraph number 8, my lord.
Yes.
The respondent bank took a decision to refund 1914,372.83 to the appellant on the account of overcharge interest. The lacuna on the part of UCO Bank was admitted before the court. Here we have completely denied. Not only that, under no document, they have reserved their rights. And my lord was rightly addressed as to why they paid. What was the so high? My lords, in my humble submission, they have not come with a clean hand before the court. They have suppressed the entire surfacing measure. This is nothing but a backlash. This is nothing but a backlash.
This happened in 2020.
This is not at all maintainable. Even if I come with the affidavit, my lord, that will suffice no purpose. This may be dismissed forthwith. This is my humble submission before the court. Whatever falls from my lord, I will follow.
Yes.
My lord, kindly appreciate, my lord, when this notice under section 13(2) was served upon me, it was like a,
What was the impending necessity
yes,
to pay
my lord,
that amount?
that was what I was trying to point out. My
Yes,
lord, kindly
yes.
takes up page 39. Now, my lord, I have given a collateral security at the time when the loan was, this is a cash credit loan. The entire amount is not disbursed to me. That is a limit that has been granted to me. According to my requirement, 1.5 crores, I can take it out. Whatsoever amount I will take it out, I will have to pay in
the interest, and kindly see page 39. Kindly come to page 39. I have given two properties as a collateral security. Back in the year 2018, when the loan was sanctioned, the valuation which was done by their valuer, kindly see the last column. That is 154.86 crore by one valuer, namely Sumit Biswas, and 163 crores by one valuer named S. Mitra. Now, in the year 2025, when the notice under 13(2) of the Surfacey Act was served upon me, calling me to make payment of the entire amount which I have withdrawn within 60 days, carrying a threat that if I fail to pay that amount within that 60 days, they will be invoking 13(4) and will be croaking my property, whose value by the efflux of time in 2025 has multiplied manifold. Now, my lord, kindly appreciate what the position I am pushed into. That if I am not going to pay immediately.
Did you reply to 13(2)?
33 was not, sir. In my humble
We are that instruction I am not having.
33 was never.
But
If you want to open up this, then I can go into those issues.
My lord, kindly let them come up with the affidavit, because
Humble submission, my lord.
Nothing. If you have not reserved your right, you have paid the entire amount, nothing. It cannot be again. Show me that you have, at the time of making payment, you have reserved your right. Please show me that.
Was cleared in the year 2025.
You could have done that. Yes, I am paying. Yes, I'm reserving my right to
well,
challenge.
kindly keep it on Monday, my lord. Kindly allow me to come back with instructions, because
What instructions?
my lord, because my lord,
What
kindly
instructions? Instructions are not necessary. You are challenging the order of the ombudsman. I will be only seeing that whether there is any impartiality.
yes, my lord. Kindly appreciate, my lord, what they have done, my lord. My lord, kindly takes a page 41,
Yes.
my lord. Under the heading,
After
under
making the
annexure
payment,
A.
you cannot now re-agitate those issues. This was open to you. You could have challenged that.
Yes, we are challenging that since from the year 2023.
That is why please show me 13(2) notice reply.
That thing we have to then file a
Unfortunately, they have not-
supplementary.
My lord, we'll be filing a supplementary affidavit.
Supplementary is not necessary. Please give me the reply.
No, we don't have it.
But that we are not having at this
I'm
moment.
not that technical. Please give me the reply.
We
I
don't
can
have it.
go into that.
We don't have it right now.
Right now, we are not having. Kindly allow us to file a supplementary
You have
affidavit.
annexed so many documents, 2 volumes, and that's the only
Well,
relevant
that
document.
question, well, that question will be falling from your lordship, which was not. Well, kindly,
You have to anticipate what the questions will fall from the bench.
kindly allow us some time. my
Because
lord.
you are, after making payment, you are re-agitating that.
No.
This
Well,
will be the
kindly-
first question.
Kindly appreciate, my lord, kindly appreciate. We are agitating this issue because, my lord, under the law, my lord, under the
You are
guide.
agitating these issues since the issuance of 13(2).
Yes,
No,
ma'am.
no.
No.
Prior
Since
to
from the
that.
year 2023. That is
Yes.
why I indicated.
At least since after 13(2) also.
No,
No.
Why?
NPA happened in 24 end.
Why
That's what
not
I'm
after
saying.
13(2)?
Yes, my lord, after 13(2) also.
Please show
Kindly
me
see-
that
kindly
after
see-
13(2). What was your reply?
Kindly see 111, my lord.
Yes.
Page
111,
111.
yes.
113, my lord. I'm sorry. I'm so sorry, my lord. 113. कहाँ था वो?
Yes, sir, कौन सा? June 2023 का letter है.
When the 13(2) notice was issued,
Although there is no whisper of sufficiency in the entire proceeding.
No, 13(2).
There is no whisper
लोग बोल
only,
रहे हैं,
not a
as per the
single
bank
document of
statement,
sufficiency has been annexed.
when 13(2) was
happened.
issued,
My lord, saying somewhere in the end of 2024, my lord.
हाँ,
they have
very
paid in
good.
the
तो हम लोग
2024.
23 से बोल रहे हैं.
2024.
24
हम लोग
end.
हाँ, तो
Yes.
23 से बोल
They
रहे
have
हैं.
completely suppressed it.
Very good.
Have you stated anything about those surface proceedings?
That is
No, that is not.
that is not pleaded, my lord.
Why?
Kindly allow us to, my lord. Kindly allow us to come with a supplementary affidavit.
Supplementary will not do.
My lord, kindly takes a page 110.
Yes.
ये भी उससे पहले और आपका
My lord,
Yes.
the payments were made in parts and parcels, and after making a part payment, we again raised the issue. Kindly see the contents of the
ये वाला पेज देखो 107.
Where is the order of the ombudsman?
Order of the ombudsman 172, my lord.
172, yes.
My lord, kindly appreciate the illegalities the bank has committed, my lord. They are charging penal interest, which is, my lord, prohibited by the as per the guidelines of the Reserve Bank of India.
अब ये भी पेज दिखा सकते हैं. This is 2024. 107.
107, na? Well, okay. And after your lordship has seen, my lord, 172, my lord, may I kindly take one lordship to page 176?
My lord, the date of the 13th would be 26/12/2024.
Very good.
26/12/2024.
So we have stated prior to that.
NOC has
Very
been
good.
issued on 23rd/9/2025.
Where, which page?
No, sir, not from the page. I have collected the documents from my client. They have not relied upon that. They are silent on
My lord, after your lordship has taken page 172, may I take, for a moment, may I take your lordship to page 176?
Yes,
176, my lord.
Yes.
Clause 5, my lord.
176.
Under the, yes,
clause-
176,
Yes.
clause 5,
Yes.
the penal interest. And the head penal interest was omitted because the Reserve Bank specifically directed the banks cannot collect penal interest. Instead,
FAQ भी दिखा दो. FAQ दिखा दो वो.
and they say that penal charges for any default can be collected, but not penal interest. Now, may I take your lordship to page 181? That is the FAQs.
Number 4.
Yes, you can.
There's no necessity to go
Yes,
into
they
this.
have charged, my lord.
Maybe.
My lord, kindly, for a moment, my lord.
One humble reply. On their
After having
document, I
paid,
have
you
not
cannot
been
again reopen this. Ashok,
No,
this
no.
application under Article 226 of the Constitution of India is at the instance of no, this application under Article 226 of the Constitution of India is directed against an order dated 7/5/2026 passed by the by the banking ombudsman being the fourth respondent. First up, alleging that the bank has charged interest at a rate in excess of the permissible rates, the petitioner approached the ombudsman with a complaint. First up, such complaint was stood closed by the impugned order. First up, the learned advocate appearing for the petitioner submits that since the bank has charged interest at excessive rates, the ombudsman ought to have ought not to have closed the complaint case. First up, the learned advocate appearing for the bank submits that the loan account was classified as NPA and the borrower, that is the petitioner herein, repaid the entire outstanding dues and the accounts stood closed. First up, the learned advocate appearing for the bank places reliance upon the decisions of the Honorable Supreme Court in the case of Central Bank of India versus Ravindra and others, reported at 2002, 1 SCC 367, and Hong Kong and Shanghai Banking Corporation Limited versus Ours and Others, reported at 2024 INSC 1044, in support of its contention that the that the court cannot interfere, that the courts cannot interfere on the premise that the interest charged is excessive under the general law and full stop. Paragraph. In reply, the learned advocate appearing for the petitioner places reliance upon a decision of the Honorable Division Bench in the case of BMW Industries Limited versus UCO Bank and Others, reported at 2022 5 CHN 372.
We are also relying on CBI versus Ravindra Mano. Kindly takes up para 53, Mano. The Supreme Court has drawn up the distinction where this honorable court may interfere.
In which decision? Central Bank versus Ravindra, page 53.
Yes.
Sorry, paragraph 53.
Para 53, page 400, internal page 401. If I may read for your lordship.
Internal page
401.
Yes, a distinction was drawn between the court's power to interfere.
Yes.
As to capitalization of interest charged. My lords, paragraph 53.
The next page, you are relying upon, while in the latter case, it would be permissible because the Reserve Bank circulars and directions having statutory force I've marked that. I will deal with that. Prior to your submitting, I have marked that. And the Division Bench judgment of the, in the case of 372. Full stop. The learned advocate appearing for the petitioner submits that if the interest has been charged in violation of the relevant notifications and circulars, the same can be challenged in a court of law. Full stop. Paragraph. After going through the order passed by the Ombudsman, this court finds that the Ombudsman took note of the grievance of the petitioner as raised in the complaint that the bank has charged excess interest in the loan account. Full stop. The Ombudsman, after taking note of the relevant materials placed before it, observed that the loan account was classified as NPA on multiple occasions and was subsequently upgraded upon clearance of overdue amounts. Full stop. The Ombudsman also took note of the contention of the bank that penal interest and charges were levied as per the sanctioned terms and conditions acknowledged by the borrower. Full stop. The Ombudsman further noted that the borrower failed to submit renewable documents and stock statements during the operative period, which triggered penal charges as per agreed terms. Full stop. The recovery action under the applicable legal framework was initiated and the borrower ultimately repaid the outstanding dues and the account stood closed. Paragraph. Taking note of the aforesaid factual position, the Ombudsman recorded that no procedural irregularity, deficiency of service or violation of the banking norms is evident on the part of the bank from the supportive documents placed on record, and in the light of such observation, the complaint stood closed. As per the provisions contained in the relevant circular. Full stop. Paragraph. On a specific query of the court as to whether the petitioner reserved its right to challenge the action of the bank in charging excess interest at the time of payment of the outstanding dues, the learned advocate for the petitioner, in spite of granting repeated opportunities, could not produce any materials in that regard. Full stop. Paragraph. It is not after having repaid the outstanding dues and the accounts to close, it does not lie in the mouth of the borrower at this stage to turn around and contend that the interest was charged by the bank at excessive rates. Full stop. Paragraph. There is no quarrel to the proposition of law laid down by the Honorable Supreme Court in Ravindra Supra that Section 21 of the Banking Regulation Act has been inserted to take away the power of the court to reopen a transaction between a banking company and its debtor on the ground that the rate of interest charged is excessive. To stop, the Honorable Supreme Court noted the distinction between the court's power to interfere on the premise that the interest charge is excessive under the general law and court's interference on the premise that the interest charged is in contravention of the circulars/directions issued by the Reserve Bank of India. First up, the Honorable Supreme Court held that in the former case, it would not be permissible in view of the bar enacted under Section 21 capital A of the Banking Regulation Act, while in the latter case, it would be permissible because of the Reserve Bank circular and directions having statutory force under Sections 21/35 capital A of the Act having been violated. Full stop. As observed here before, that the petitioner was the borrower has repaid the outstanding dues without reserving any right to challenge the same at a later point of time. So, thus, the decision in the case of Ravindra Supra cannot come to the aid of the petitioner in the case on hand. Full stop. In BMW Industries Limited Supra, the Honorable Division Bench Where is that paragraph? Where the Honorable, in BMW Supra, the bank took a decision to refund the amount on account of overcharged interest. Full stop. Thus, the said decision, being distinguishable on facts, cannot come to the aid of the petitioner. Full stop. In Hong Kong and Shanghai Banking Corporation Limited, the Honorable Supreme Court reiterated the well-settled proposition of law that Section 21 capital A creates an embargo upon courts/tribunals to reopen and adjudicate upon transactions on the ground that the rate of interest is excessive. Full stop paragraph. After hearing the learned advocates for the respective parties, this court does not find, and after considering the materials on record, this court does not find that there is any infirmity in the decision-making process. First up, WPA number such and such accordingly stands disposed.
I'm grateful, my lords. I'm grateful.
Next.
Item number 73.
I take my lord's leave, my lord. I'm grateful.
Item number 73.
Passover, yes. So Dharas come.
But
Let's call the Passover. Yes. Yes, Mr. Dhar. Photograph taken? Yes. What is the report? I asked you to file a report.
No, only have managed to send a person there and take the photograph, Lordship. This is the yesterday's photograph. Before and after 20. আর বলছি তো প্রত্যেকদিন পরিষ্কার হয় as I have taken cleaning process.
Yes.
And there is this bin is also installed. And Lordship, I have also, the concerned department was helpful. They have also made a compilation of on 14, 15 what happened, Lordship, all before and after. Every day, the entire garbages of the ward are stored in the bin. Thereafter, at 12:30.
Where is that signboard? You have removed that.
That signboard.
Where is that picture?
Lordship, kindly appreciate. Can you appreciate the nature and character of people cannot be changed? Instead of signboard, everyone will throw.
No,
And
no, I'm asking you, where is the signboard? Where is that photograph of the signboard?
This belongs to the same area. Same area.
Signboard. Where it has been removed, Mr. Dhar?
Kindly tell us it with the signboard is still there. Signboard is still
Where is that? Where is that? Photographs. You should take the photograph of the bin along with the signboard. That you have not done.
The bin is there, Lordship.
Signboard along with the signboard. Yes. Yes, madam, what is your instruction? Now it has been cleaned. It's still there.
It is still there, but it will be there.
Every day people will try, every day we will.
Law, my lord, but let us discuss one thing, law. The wastage of the garbages are primarily collected in all the houses, and thereafter they are stored as a secondary collection in those cases, my lord. So this is a case of a secondary storage facility. Now, my lord, what is the law in that regard? So, my lord, the lordship sees the Central Pollution Control Board standard operating procedure.
Yes.
এটা তুইও রাখ একটা তোরও ভালো লাগে। So it speaks, it has come into operation in the year 2025, April 2025.
So you are on secondary storage.
Yes, my lord.
Yes.
What is secondary storage, my lord? The definition is given, my lord, in page 1, my lord.
Page 1.
44 of page 44.
Yes, page 44, yes.
It speaks first the primary collection. What does it mean? Means collecting, lifting, and removal of segregated solid waste from source of its generation, including household, shop, office, and any other non-residential premises, or from any collection points or any other location specified by the local body. That is the primary collection. What is secondary collection? Secondary storage means the temporary containment of solid waste after collection at secondary waste storage depot or MRS or bins, for your bins we are talking about, for onward transportation of the waste to the processing or disposal facility. So here we are dealing with secondary storage. Now, my lord will find in page 47 what is the status at the present of this secondary storage facility. So it says that secondary, my lord, it's page 47 status. Page 47. So what are the disadvantage of this metal bins? It speaks about that. Status of secondary storage facility. Secondary storage facilities are required for secondary collection of waste. In most of the cities, such waste storage depots exist, which are either civil structure, concrete bins, metal bins, hollows, which was specifically not addressed in the SWM 2016. Indiscriminate disposal of unsegregated waste, which is not permitted as per SWM 2016, is observed at such facilities, leading to adverse impact on the surrounding, including the following. What are the things? Odor and batsmen, littering, leachate, contaminations, pest and vector breeding, traffic congestion, which is happening in this case, man. Thereafter, the SOP has been formed. The SOP is in page number 48. The SOP says the classification of SSF and STF. So it classifies what is secondary storage facilities and the secondary transfer facilities. The important portion over here is a criteria for identification of location for setting up SSF and STF. Which is in page
Yes, Mr.
41.
God, please file a report as to whether you have followed these procedures.
Then we will give opposition to this. We will use our opposition.
What opposition?
Opposition to this petition.
Report, no opposition. Whether you have complied with this.
And with regard to what she is stating, with regard to same issue, a matter is pending before the NGT, the same issue.
What?
With regard to the following of
It's a central pollution.
Yes, where it is pending
NGT.
with regard to your municipality.
Yes. Siliguri Municipal Corporation. With
Look
regard
what you are doing.
No, there we have filed our complaints report also. We have filed our complaints report also.
You have filed.
Yes, we have
So
filed.
then you can file a short report on that you have complied with that. Then you cannot, don't need much time because everything is ready there. You have filed a compliance report, you can disclose that. Thank you, Ashun. The grievance of the petitioner is that the standard operating procedure for secondary storage of secondary storage facilities under Solid Waste Management Rules 2016 has not been followed by the Siliguri Municipal Corporation. First up, let a report in the form of an affidavit be filed by Chief Executive Officer.
No, the commissioner.
By the commissioner.
By the commissioner.
Be filed by the commissioner, Siliguri Municipal Corporation, being the third. With regard to the allegations contained in the writ petition. First of such report in the form of an affidavit shall also deal with the procedures followed by the municipality for selecting the secondary storage facility, the site for secondary storage facility. First up, let such report in the form of an affidavit be filed. When? Tuesday? Everything is ready, you have said, compliance. You will be only adding those, what is the procedure and the compliance reports. Done.
Lordship.
When? Wednesday? This report be filed by 29th, list this matter on 29th. Every service taken on record.
And Lordship was searching for that board. That board is there, Lordship.
Where? Because that board is an attractive board.
Yes,
I want
yes,
to see
the
that.
board
Where
is
is that? Where is the board, Mr. Dhar? Yes.
देख लिया मैंने अरे है তোমার WhatsApp এ তো ছিল
They are removed. So now they are asking the persons to throw there. Yes, call. Yes. Yes.
But I appeal for the petition now.
Yes.
And the dispute relates to the payment of employer share under the ESI Act, my lord. And my lord, also what happened, my lord, the present
Who is
payments are
appearing for
being
the
made.
ESI authority? Who is appearing for the ESI authority?
Item number 68.
Yes, yesterday they were there. Yes, who is appearing? From principal bench. Here you don't have anyone. Where is Miss Pandey? Not today. Next. Yes, next. Yes.
Please, my lords, I am appearing in this matter, my lords. This is a custom matter, my lords,
Yes.
wherein we are challenging the Caesar memo. My lord, this is a custom matter wherein we have challenged the Caesar memo issued under section 110 on the jurisdictional ground that, my lords, no reasons to believe has been recorded. My lords may have the Caesar memo, Caesar list at page 30, my lords, page 30. And my lords,
Page 30, yes.
my lords, this is a Caesar list. There is no such panchnama, nothing has been there. No reasons to believe have been recorded. Page 30, my lords. My lords may have, my lords have it. My lords may see the first serial number, betel nuts, believed to be of foreign origin.
Where is the show cause notice?
My lords, the show cause notice is at, my lord, page 52. It starts with page 46. Page 44, my lords. They sent my goods to the ARDF laboratory. They have recorded in the show cause notice that it resembles of India. I may just hand over the report.
Have you replied to the show cause notice?
Yes, my lords, I have filed the reply. My lords. They themselves are recording in the show cause notice that the good resembles of Indian origin. My lords may have page 48, my lords.
Yes, have you adjudicated the show cause notice?
Completion of all formalities. Show cause notice has been issued by the customs officer. And in the show cause notice, it is categorically mentioned that if any reply, because I
That he has done.
I reply, and after, and in the Shobha, in the observation, if you are willing to appear physically or any personal hearing, in that case, you have to mention the same. In the Shobha, they have not mentioned about the personal hearing matter. Subsequently, the issue petitioner has issued another letter wherein we pray for personal hearing. And my instruction is that notice for personal hearing has been issued. So,
When is the hearing fixed?
just one phone, it has been instructed to me. I have no document to that. Just
Nothing has been
just recording on the further completion. Moreover, as per section 120 of the Customs Act, he has every opportunity to prefer an appeal. If
No, that is, you are taking a step further. Yes,
My lords may hand over the copy of the my lord report. Copy of the report, my lords.
yes.
They themselves sent my goods.
No, provisional release, you have filed an application for provisional release.
Yes, my lords.
So,
I have filed
has it been adjudicated?
No, my lords. It has not been adjudicated, my lords. till date.
But I'm very much sure that the notice has been issued today. It cannot be yesterday. Since by the today the
So I have directed, since the date of hearing has been fixed, I directed you appear before that authorities.
My lords, the goods are to be provisional.
If the hearing is fixed, you appear before that authorities, the matter can be decided there.
No, my lords, I'll apprise my lords why this writ petition has been filed, my lords. My lords, I'll apprise why this writ petition has been filed. My lord, this writ petition has been filed to challenge the reasons to believe that they have that its belong of foreign origin has been contradicted by their own report, which states that
point has been mentioned in the reply. In their reply, the reasonable point has been mentioned in their reply. Let the authority adjudicate the entire issue.
My lord,
Yes, where is your application for provisional release? Please show me.
my lords, it's at page 31, annexure P4. It's been pending since 17th of October 2025, my lords. Page 31. And my lord, despite the fact that my goods are of Indian origin according to their own report.
Yes, Mr. Bunik, why have you not decided this application? It's pending from 17th of October 2025.
They have filed only provisional release.
Yes, why have you not decided that? They want now provisional release.
They have not filed any document. Wherefrom they procure the NCLR.
Have you decided, Mr. Bunik, you rejected their application for provisional release? You have not decided. How soon can you decide this application for provisional release?
Adjudication process within
Provisional release, adjudication will be done, provisional release. When can you decide? How soon can you decide this? You take time in the adjudication, decide this provisional release. Yes, take time for adjudication. But how soon can you decide this provisional release?
Before provisional release,
One of the reports is there. If you say that, I will consider that, I will direct you to release those provisionally here and now.
The coordinate bench
And if you want to decide that provisionally, do that at the earliest. How soon can you decide? Not 4 weeks. Not 4 weeks, within 2 weeks. Unless you decide within 2 weeks, then it has to be released. Yes, where is that? Please show. Yes, yes. One report you have obtained. Have you disclosed that in that order? So cause.
Yes, my lord, they have disclosed.
Please show me that.
Mentioned in our aggregated notice.
Yes. Please show me that that report which is in their favor.
Everything I mentioned in the application notice. My lord, kindly.
Yes.
Page number 52.
Page number? Yes, 52. Yes.
In 4.65. 4.6. Representative samples of seed containers were sent to ARTF Bengaluru on 10/10/25 for determination of country of origin.
No, where is that report which says it's of Indian origin? Please show me that. Which paragraph? Yes, which paragraph states, which report states that it's of?
My lord, for para 4.6, page 52.
Page 50.
52, para 4.6. May I read it, my lord? Para 4.6. Thereafter, on the request of the owner of the goods, resampling of the seized betel nuts was done on page 52, my lord.
That is the first report.
Secondly.
Yes, the test report dated ARDF Mangaluru confirmed that representative samples of betel nuts are mostly resemblance of American nuts, betel nuts of India.
Yes, my lord.
4.6, last sentence.
4.6.
Mr. Bonik, can you decide that at the earliest? Because this document is there which says it's of Indian origin.
And my lord, the coordinate bench.
Coordinate bench has directed this.
Yes, my lord. May I just hand over the
Please
copy
see
of
the
judgment
coordinate
of
bench judgment. Just directed.
Justice Chandra's order, my lord.
I give you liberty if you want. Please decide that within 2 weeks. Not possible. Don't bargain with the court. Ashun, the petitioner has the primary grievance of the petitioner is that the prayer of the petitioner for provisional release of the seized items has not yet been released. Full stop. The learned advocate appearing for the petitioner draws the attention of the court to the to paragraph 4.6 under the heading investigation and findings in the notice to show cause dated 9th of April 2026 in support of his contention that the test report dated 23rd of January 2026 of ARDF Bengaluru confirmed that the representative sample of betel nuts are mostly resembles to the areca nuts / betel nuts of India. Full stop. Where is that you are using it for industrial purpose? Where?
My lord, that is.
No, in the reply you have stated, no, in the application for provisional release you have stated that. Please show me that.
My lord, in the application, we have not given that, but we are ready to give an undertaking for that, my lords. We are ready to give an undertaking because under my lord,
the learned advocate for the petitioner further submits that the petitioner is ready and willing to give an undertaking before the authorities that such seized items shall not be used for direct human consumption, but shall be used for industrial purpose. Full stop. Mr. Bonik, learned advocate appearing for the customs authorities, submits that at least 4 weeks time be given to the authorities to decide the prayer of the petitioner for provisional release of dried areca nuts within inverted comma. Full stop. Considering the fact that the goods were seized on
10th of October 2025, my lords.
on 10/10/2025, and the application for provisional release of the seized articles
17/10.
was submitted submitted by letter dated 17th of October 2025, WPA number such and such stands disposed of by directing the by directing the who will consider this?
My lords,
Yes, Mr. Bonik, who will consider this?
respondent 3.
By directing the
Respondent 3, my lords.
by directing the Commissioner of Customs, Preventive, Kolkata CCP being the third respondent, to consider the prayer of the petitioner for provisional release as contained in the letter dated 17th of October 2025 by passing a recent order of as expeditiously as possible, but positively within a period of 3 weeks from the receipt of a server copy of this order together with a copy of the representation dated 17th of October 2025. Yes, what is this notification for?
As per Ministry of Commerce and Industry direction, Indian betel, the minimum value of Indian betel nut is 351 per day. This is the direction given in the document. But from their Chalan, it's mentioned that they have purchased the
You reject the prayer. You reject the prayer. Decide it in one way or the other. I'm not going into the merits. It is, however, made clear that for what? Have I gone into the merits? I have only directed you to decide that issue of provisional release. It is, however, made clear that this court has not gone into the merits of the claim made by the petitioner in the application for provisional release of the seized items, and all points are left open to be decided by the said authority. Yes.
they have failed to provide a document.
Yes, call the next matter.
Obliged, my lord.
My lord, item 75,
Yes.
my lord, I beg to appear virtually, my lord. Item 75,
Yes.
my lord. Lordship may remember, my lord,
Yes.
this similar petitioner yesterday heard, but this case fact is little different except additional notices and quota. Additional notices and quota, there is similarity. What happened, my lord? In brief, my lord, first issued show cause notice in 2022. And my lord, we filed reply, paid taxes, case dropped. We are not on that way. Now, my lord, pre-show cause notice in DRC 01A issued intimation, that is intimation. Thereafter, my lord, show cause notice issued, and the show cause notice date of personal hearing mentioned prior to date of reply. Thereafter, one adjournment issued, personal hearing noted. Thereafter, another adjournment notice issued. There also date of personal hearing prior to date of reply. Thereafter, my lord, ex parte adjudication order passed, and all these in the additional notices tab. And what happened, my lord? Before passing of order, the petitioner, on the basis of DRC 01A, paid 1,50,000 rupees with reference to the DRC 01A, and that was not reflected in the order. But importantly, my lord, all these as uploaded in the additional notices tab, your petitioner missed. Then on 5th March 2026, department telephone that you have a demand. Then, my lord, the tax consultant by mistake filed the against the intimation with reference to section 107 says the appeal can be filed only against the decision and order. This is neither decision nor order. I do not know, my lord, how the portal allows
Yes.
to file appeal. Thereafter, my lord, appellate authority passed the appellate order and mentioned that appeal rejected on the ground of limitation. But my humble understanding, my lord, this filing of appeal is also itself void, illegal, my lord. So appeal ought to have rejected on the ground of that order, appeal not filed against the appellate order. Thereafter, my lord, on 18 May 2026, they passed the appellate order, and for another year, my lord, your lordship passed order yesterday. On 18 May, they have issued one recovery intimation. Thereafter, my lord, we contacted with the engaged new tax consultant, and thereafter filed restitution. So, my lord, in my humble submission, my lord, noting all the fact, my lord, matter may be remanded to the adjudication stage to file. Another important aspect, my lord, after passing the order, my lord, before filing of appeal, your petitioner, on the advice of tax consultant, paid another 4,556,000. So total, my lord, 5,50,556 paid. That is 30 out 8% of the disputed tax. So that may be incorporated in the new order, subject to your convenience. No, my lord.
Yes, Mr. Yes.
Kindly have a look, my lord, the pre-show cause notice at page 69, my lord.
Yes, Mr. Mishra, what do you say?
I am requesting Mr. Mishra to use microphone.
Negligence is.
I am requesting Mr. Mishra to use microphone.
Or that accountant is not made party, that accountant cannot say anything. This is something in their personal knowledge. We do not know whether the accountant has committed a mistake or not. Where do we draw the line, my lords?
My lord, record says, my lord, we have attached all these documents, and my lord, there is a judgment, my lord, for.
If any query is put, they say it's personal difficulty. In business field, this happens. Accountant was negligent. Accountant was negligent. Have you proceeded against the accountant? It is governed by ICAI Act. Section 29 thereof is regarding disciplinary proceeding against the accountant. Civil suit should have filed against the accountant. I mean, I understand. I also used to stand on that side. Not very recently that side, but no, this has to end somewhere.
You have changed, Mr. Mishra.
I haven't changed yet. I'm trying to change. But after standing from this side, I have realized that not everything that is said from that side can be believed in also. What do we do? The authorities, they give them opportunity. Additional tab matters. Okay, additional tab, it was uploaded. Even additional tab is a part of a portal. 169(1) says that anything that is uploaded on the portal is a intimation.
Regarding the part of the filing of appeal is the second part, my lord, subject to your lordship correction, my lord. And first part is
herein what has happened, instead of the adjudicating or authority's order being challenged, they challenge some other order. 107 says any order of the authority can be challenged. So if they do not challenge the proper order,
they have not challenged the order.
No, they have challenged something else. So that is also permissible. The act permits them to challenge any order. They have
No, they have not challenged any order. An intimation or something
that has been challenged by them.
So against that appeal does not lie.
Does not lie.
So, but the authority has also dismissed on the ground of limitation.
But the actual order, the adjudicating order passed under 73 or 74, that was never challenged.
That he says that that was an ex parte order
And why that was challenged? Because the accountant was negligent. The RTP is not negligent. It is the accountant who was negligent.
Because,
And the RTP did not follow it up also.
Yes, because they depend on the advice of the accountant. This is the accountant who really advises the client whether to challenge or not to
Because
challenge.
today, as an advocate, if I give a bad advice, tomorrow somebody can proceed against me before the bar council. In case of accountants also, there is a statutory authority that is there that looks into those complaints. Where is that complaint that has been made to the authority? Where is section 29 proceeding as per the Cost and Management Act?
Yes.
Honorable
do you say?
Yes, my lord. For
Everything thrown on the shoulder of the
my lord,
accountant.
for the appeal part, my lord. Appeal file.
Particularly when he himself had ticked the option that he does not want a personal here. How this person are getting aggrieved then?
So when you have filed an appeal, it shows that you are aware of those.
No, my lord.
You are aware of those.
My lord, honorable.
Cannot be said that you are not aware of the orders.
No,
Maybe
and
you have
that-
filed against the intimation.
That's wrong.
That's up to you. You cannot say that you are not aware of the order.
My lord, again,
Having
that, my
filed
lord.
an appeal.
Yes.
So now you cannot take the benefit of additional tabs and other things. Those are gone. Once you prefer an appeal.
Right, my lord. Your lordship is correct, my lord.
Then,
but my lord,
then
I am asking myself.
in all matters, you cannot take the benefit of additional tabs.
We have been very liberal in these matters.
My
To
lord,
be
my
very
lord,
honest,
I am
but then
asking
we have been
myself-
very liberal. But then some line has to be drawn somewhere.
My lord, I am asking myself.
Tomorrow
my lord,
anybody will come after
Yes,
5
what
years,
is the
7 years,
difference?
10 years.
Only
Yes.
one thing can be done. You have said that you have paid 5.5 lakhs and odd. That can be directed to be adjusted.
Yes, my lord.
That is so. That can be directed to be adjusted.
Payment already made has to be adjusted.
Has
That
to be
is- that is-
adjusted.
my
That
lord,
can
my
be
lord.
done.
My lord, my,
But other than
my
that,
small
no other
So,
interference is
what
required
is
to
the
be
total quantum?
total tax in
Where is
dispute,
the, where is
my
the
lord,
demand?
total tax in dispute, my lord, 14 lakh 56,889. Page 94, my lord. And
Page 94.
operative part, my lord, order part, page 114, my lord. Page
114.
114. Tax,
114
tax, 14 lakhs 56,899.
14 lakh 56,899.
99. Out of
So
that,
out of that you have paid 5.5.
5.5 lakhs, my lord. And
So balance you pay, I direct them to adjust.
no, my lord, here, my lord, your lordship may, my lord, because, my lord,
They want to delay it. They
my
again
humble
want to go back to
understanding,
the
my lord,
adjudicating
the
authority,
postal-
and then they will
What
again.
what will be done? Because this is the only dispute. What is the other dispute? There is no other dispute.
No, my lord, we are
So I
challenging
direct
the-
them to adjust this.
my lord, matter may be remanded to the adjudication, my lord. We will file reply. my
Why?
lord.
For what? For what? For what purpose? What is the defect in the order accepting that 5.5 lakh adjustment?
No, my lord, in merit, my lord, there will be, after that, no tax is payable. We in 150 page 50, para 50 to 56, we have dealt the in merit also, my lord. And there is important submission, my lord. For the fault of tax consultant, my lord, petitioner may not suffer, my lord. We are relying, my lord, your honorable apex court judgment in the case, my lord, Rofik versus Munsilal, my lord. I am requesting my learned junior to hand over the copy of the judgment, my lord.
These are all circuitous litigation. Again going back to the authority, again coming back. Again
There are
going back.
contrary judgments also.
Yes,
There
yes.
are contrary judgments also.
Yes, my lord. And my lord,
If
in
you
the
show
law
judgments on this, there are contrary judgments.
Yes,
Why
my
the
lord.
accountant has not been
There
made
are
party?
contrary judgments. You have to proceed against that consultant.
Yes, my lord.
Unless you show, yes, merely
For the-
putting the blame, you have to implicate that tax consultant as a party.
His reply is important.
Yes.
My
If
lord,
you
my
take
lord.
if you take those points, then you have to
No, no,
implicate
no.
the tax consultant,
I'm
merely
not
blaming
going,
the
my lord.
tax consultant behind his back. That will not do.
My lord, then my lord, subject to correction.
So
my
be
lord.
careful before relying upon those judgments, because then I will direct you to implicate the tax consultant. I will also hear the tax consultant, whether after all the tax consultant or your client was at fault.
Yes, my
Putting
lord.
the blame of tax consultant.
My lord, then,
So
my lord,
if you want, Mr. Rai, this adjustment can be made.
My lord,
adjustment can be made.
my lord, liberty may be given to the approach to the appellate authority, my lord. Because, my lord, my rights, my lord, I have not heard, my lord, the ex parte adjudication order passed, my lord. And, my lord, law says that appeal can be filed against the order, my lord. So kindly have a look, my lord, section 107, my lord.
So what do you say? The appeal was dismissed on the ground of
I will leave it upon my lordship, but there are two things. One is these are all circuitous litigations. Second one is how are they using the writ court as a court of extension of statutory
But only one
limitation?
thing, if this date of before filing the reply, if the date of hearing is fixed, that cannot be done.
That cannot be done.
So that's violation of the principles of natural justice.
Yes, my lord. Yes.
So if that order was passed on that,
Let the amount be adjusted. The appellate authority will look into it. The amount after adjusting the amount, whatever the balance is, that will be looking into it.
So
That is the best that we can do.
deposit required, my lord. That 10% may be adjusted from here, my lord. Because for ends of justice, my lord, case may be hard on merit, my lord.
But the problem is that these orders will again be produced as a usual order, and then thereafter, the same thing will continue.
So this type of fact is, my lord, I got first time, my lord. That
the other
appeal
thing is,
against the
Mr.
intimation,
Mishra,
my
what
lord.
will happen is that if the appellate authority finds that there is, you have filed the reply to the show cause.
No, my lord. No, my lord.
Yes.
No, my lord.
No. The reply to the
no,
show cause is there.
No, Mr. Mishra, that is first so cause.
After they have made the take,
that was drawn.
Please see whether the reply to the show cause has been filed.
in the reply to the show cause, they have only uploaded DRC 03.
No, my lord. I am saying, my lord.
And then they say personal hearing not required.
No, there here the date was given. Have you submitted the reply to the show cause?
No, my lord, no. Our show cause is because, my lord, uploaded in the additional tab, my lord. Page 77 is the show cause, my lord. Kindly have a look. Page
No, before the
77.
64 show cause was also there.
No, my lord. That was I have submitted at the outset, my lord. That first show cause notice issued. We paid the entire amount. They dropped.
Where is
order.
the second show cause notice?
Yes,
Where is the second show cause notice?
That case, my lord, 77. 77. my lord.
77.
7. This is our case. As a officers of the court, we should not suppress the fact. That is why I have annexed the first show cause, first order. That was dropped. We are not on that. We are not challenging on that in our prayer. And, my lord, kindly have a look, my lord, page, my lord, 88, my lord, page 88. The personal hearing part, my lord, page 88.
Page
88. That date of reply 15 June, date of personal hearing 17 May. That cannot be, my lord. Page 88, my lord. Lordship got, my lord?
Yes.
And, my lord, kindly have a look, my lord. Next page, my lord. Because I am officer of the court, I should not suppress. Page 89, my lord. This is the first reminder. Lordship got, my lord? Here personal hearing noted, my lord.
Here there is no mistake.
No.
Here there is no mistake.
Yes, but next, my lord. Kindly next page, my lord. Next page. The last hearing, my lord. Page 90, my lord.
Mr. Mishra, what are you doing? How are you proceeding in this matter?
No, my lord, sir. As far as this one is concerned,
yes. You are fixing
the
a
one
date
has-
of reply after the date of hearing.
no,
And
sir.
all this, my
Page
lord,
90.
90, my lord. Thereafter, my lord, ex parte order passed, my lord. And all this in additional notices tab, my lord. That, my lord, yesterday I have relied, my lord, the Honorable Justice Kaushik on the order, my lord. Ashok Parak in the case of. Your lordship also recorded yesterday's order. And also covered by your lordship order, my lord, Shankar Agarwal, where there was delay in appeal. And also your
Yes, what do
lordship.
you say to this, Mr. Mishra?
Yes, my lord, sir, I've seen that.
Your lordship order Shankar Agarwal and relying the division bench order Ram Kumar Singhal. I am requesting
It
my
appears, my lord, they have been called for a personal hearing on 29th and written can be taken up to 31. They had been called for a personal hearing on 29th, but their reply
Where
may
is
be
that? Where is that?
on page 90.
Yes.
The date of personal hearing is 29/7.
Yes.
and date by which reply has to be submitted is 31/7. I think
Yes.
these two, my lord, so they are disjunctive. So what is being intended was
Yes. So can a personal hearing be prior to submission of reply?
the last date of reply submission is 31/7.
Yes. So how can the personal hearing be prior to that? Please show me that you have fixed the next date of hearing after that. And when the order of adjudication was passed?
My lord, at page
That, my
94, my
lordship,
lord,
is
20th August
order
2024,
of
my lord.
adjudication was passed.
Page 94. Starting page, my lord.
What is the date?
20th August
What is
2024.
the date?
20th August 2024.
No, the date is not here. Where is the date?
Yes, my lord.
That would
Date
be
is
at the
at my
end.
lord.
I'm just checking it out.
Date at my lord page. Page, my lord.
Yes, 20th of August 2024.
20th August 2024.
Yes. Page 113, my lord. Date mentioned.
Yes, then Mr. Bisro, the adjudication order has to go on this.
Yes, my lords.
Ashun. The ex parte adjudication order dated August 20, 2024 passed by the Assistant Commissioner of Revenue, Jalpaiguri charge SGST under section 73 within bracket 1 of WBGST and CGST Act 2017
Tax period 1920.
is under challenge in this writ petition. First up, the grievance of the petitioner is that the pre-show cause notice, the show cause notices, the reminder letters, and the adjudication order were never uploaded by the revenue under the notices / orders tab. Judgment from that tab on the GST web portal. First up, it is the specific case of the petitioner that such notices and the order of adjudication were uploaded under the additional notices and orders tab. First up, the petitioner states that he came to know for the first time on when?
On my lord, 5th March 2026, para 23 of the writ petition, my lord. 5th
On
March
5th of March 2026. That an ex parte adjudication order dated August 20, 2024 was passed. First up, the learned advocate paragraph, the learned advocate appealing for the petitioner submits that since the petitioner was not aware of the show cause notices, he could not participate in the proceedings. First up, paragraph, Mr. Misro, learned Assistant Additional Advocate General, submits that that an integrated online platform for the taxpayers were created and the notices and orders were uploaded in the said portal.
As per 169, it is sufficient.
As per section 169 of the WBGST Act 2017. WBGST slash.
It is a deemed service.
Slash BGST Act 2017. First up, it is now well settled that publication of notices and adjudication orders in the additional notices and orders tab cannot be said to be a communication as contemplated under section 73 within bracket 1 of the WBGST/CGST Act. Full stop. That apart, it appears from the show cause notice dated
14 May 2024.
show cause notice dated 14/5/2024 and the reminder letter dated 24/7/2024 that the date of that the date of personal hearing has been fixed prior to the time limit fixed for submission of reply to the show cause notice. Full stop. That by itself goes to show that the principles of natural justice has been grossly violated. Full stop. Since the notices and the ex parte adjudication order was uploaded in the additional notices and orders tab and not under the normal tab, this court is of the considered view that the petitioner cannot be faulted for not participating in the adjudication proceedings. Full stop. For such reason, this court is inclined to interfere with the order of adjudication dated 20th of August 2024.
2024.
20th of August 2024. Full stop. Paragraph. Accordingly, the order of adjudication dated 20th of August 2024 is set aside and quashed. Full stop. The petitioner is granted liberty to file the reply to the show cause notice within a period of 14 working days from the receipt of a server copy of this order. Full stop. The Assistant Commissioner of Revenue Siliguri charge is SGST being the
Respondent number 5, my lord.
Being the fifth respondent is directed to decide the issues raised in the show cause notice as expeditiously as possible. Decide the show cause notice afresh after affording an opportunity of hearing to the petitioner and by passing a reasoned order as expeditiously as possible. Full stop. It is however made clear that the order of adjudication has been set aside, has been interfered with by this court only on the ground of violation of the principles of natural justice, and all points are left open to be decided by the said authority at the time of hearing. Full stop. At this stage, the learned advocate for the petitioner submits that the authorities did not take into consideration the amounts which the petitioner has deposited in the meantime. Full stop. It will be open to the petitioner to raise such plea in the reply to the show cause notice. Full stop. If such plea is taken, the adjudicating authority shall consider and decide the same while passing the reasoned order.
My lord, subject to correction,
Yes,
my lord.
Mr.
My lord, subject to correction.
No, my lord, sir.
My lord, subject
Yes.
to correction.
No, my lord, sir has already dictated the order. If I can have my lordship for a moment on page 3. They know the email, page 3, cause title. They know the email addresses of 4 and 5. They could have easily written an email and asked that, what are you doing? Give me another date.
No, 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 no.
Page
That
3.
is
The cause
collected.
title.
That is collected
The
later.
email IDs are also there.
No, no, no. That is
When they know what the email ID of the officer is, they could have easily corresponded with the officer.
My lord, subject to correction, my lord. One line, my lord, subject to correction, my lord. One line may be noted, my lord. That appellate order may be set aside, my lord, subject to correction. Appellate order.
When the adjudicating author has gone, then what with the appellate
If
order?
the adjudication order goes, what remains with the appellate order?
Yes, my lord. This is subject to correction, my lord. Subject to correction. 136, one line.
What
may be-
remains with the appellate order?
Yes, my lord.
Appeal was dismissed against an intimation.
Yes,
Now
yes.
the adjudication order goes.
Yes, my lord. My duty, my lord, to investigate your lordship.
Every service taken on record.
I'm grateful, my lord. I'm grateful, my lord.